Yes, Your Honor.
All right. All right, here's what I'm going to do. Is that right, ma'am? You want some dates?
Yes.
All right, so discovery is the exchange of information. I'm going to give you the opportunity to conduct discovery. Discovery will be concluded on April the 24th. Nobody demanded a jury trial here, correct?
That's correct, Your Honor.
All right, we're going to give them a trial date. I'm going to put down 1/2 hour for trial. Witness lists are due by March the 24th of 26. You do not have to file a trial brief. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial date. All motions for summary have to be filed and heard not later than 20 days before the trial date. I'll give them a date in May. I don't know who's Jennifer or who's out there.
I'm out. Judge, I'm here. Yep.
Yeah, I don't know who, what days I gave on a couple trials yesterday in May, I believe. If we could do the same date, that would be perfect. If you know, if not, we'll set another.
I don't know offhand, but we can do May 4th at 10.
Well, he's gonna have an opportunity to file.
You want to go to the 18th then? With that
May 18th, it's still at 10?
10:30.
10:30. Okay, so I'll send this out. Ma'am, if they have documents that you want, you can make a written request for those documents. You can conduct discovery, again, which is the exchange of information. So I'm going to go ahead and send out this pretrial order. We'll prepare it, and you should have it by the end of the week. Okay? Anything else, Ms. Portis?
No, that's it.
Mr. Goethals?
No, that's it, Your Honor. Thank you.
Thank you. Have a good day, everybody. Midland Credit versus Jill Diaz. 2504147. Here.
Your Honor, plaintiff's counsel logged in on this one. He advised that she is paid in full, so they are submitting a dismissal with prejudice on M file today.
Perfect. I'll just make a note, stip in order to dismiss being submitted. Do you have a way, just in case they forget? I don't want this sitting idly.
Yeah, I'll keep a note.
Perfect. LVNV versus Holly Martin, 2504458. Is Holly Martin here?
No, Your Honor. Pamela Anderson appearing on behalf of the defendant, Holly Martin.
Good morning, Ms. Anderson. Mr. Nate, good morning to you. Your name?
Good. Preston Nate, P777884 for LVNV.
Am I just setting dates on this one as well?
Actually, similar to the last case, this one's resolved. We'll just be getting a dismissal submitted to the court. I'm going to get that over to Ms. Anderson today.
All right, so you're going to send over the stip in order to dismiss, Ms. Anderson?
Actually, Mr. Nate is. I am going to sign it once he sends it over.
Yeah,
okay.
I'll get the signatures and then I'll take care of it.
Thank you both. Have a great day.
Thank you, Your Honor.
Ronald Langlands versus Cars and Trucks Engines for Less. 2600390. Okay. Do I have somebody here for Cars and Trucks Engines?
I'm here in this room.
What's your name, sir?
My name is Michael Ariet. Good morning.
Okay. Okay. Can you spell that for me?
Michael, Michael, last name Ariet.
Good morning to you.
Good morning.
And in your appearance, sir, your name?
My name is Rob Evans.
All right. This is a small claims action. What is your position with the defendant, Mr. Arrieta?
Okay.
You have to start your video again, sir.
I'm sorry. You cannot hear me?
I can hear you, but I can't see you. I need to see you. You shut off your video.
Okay, hold on. Okay, I don't know why I cannot see it now. I was
Bottom
able to
left-hand
see it
corner.
a second ago, but I'm not sure why I
Should
cannot
be
see it
bottom
now.
left-hand corner of your screen, sir.
Yeah. Yeah, that's what I'm sorry, that's what I'm clicking, but don't know why.
I cannot conduct a hearing if I can't see you is the problem.
Okay, can I try with another device?
I don't care, but I'm gonna go on to another case. I want to know before you try the other device, Mr. Langland. You need to be able to prove that he sold you a defective engine. I just want you to listen to me. You're not a certified mechanic, right?
My witness, yes.
Okay, well, he's gonna have to come up here when Mr. Arietta gets everything situated here, okay? So you're gonna have to start your video, sir. And I'm gonna go on to another case. If you'll have a seat, Mr. Langlands, I'll be right with you. Kevin Dale Farnham, 23W8324998 A and B. Name?
Name's Kevin Farnham.
So what do you think I'm thinking? Huh?
I have no idea, sir. I mean, here, here.
Well, this is 2026.
Yes,
And it was a 2023 case. And we haven't seen you, haven't heard from you. So that should be a red flag to you. The ticket was issued back in June of 23, so you're only about, let's call it 32 months late. Why haven't you been here? You don't do this in other courts, do you?
no, I
You don't
don't.
pay your mortgage payment 2.5 years later, do you?
No,
Okay, come on, use your head. Where do you work?
I work for Davy Tree Company. I do line fence tree trimming for.
What excited you or enticed you to come in here today, 2 years and 8 months after the fact?
I got put on probation a few months back and then this was brought to my attention. It was a ticket that I just forgot about.
Forgot about it. I
Yes.
hate that word. How do you forget about it? I want to forget about a lot of things. But anyway, listen to me. You have all the money to pay this?
I don't have all of it. I was hoping to get on a payment plan and then take care of.
You gave yourself a payment plan when you didn't show up here seriously, for
Yeah.
32 months.
No, I understand.
How much do you have with you?
I could do like $100 a day.
You owe us 426.
And I could pay weekly.
What are you on probation for?
I was drinking and driving.
Drunk driving where?
The Illinois Park, I actually got in court today with them after this matter.
When can you pay $100 more after your 100 today?
Next Thursday, I get paid on.
Are you sure?
Yes,
You pay 100 today.
yes.
You pay 100 more by, let's see, today's the 24th. 100 more by March the 5th. That's on the expired plate. You owe 213. I'll waive the balance, okay?
Okay.
So I'll waive $13. Now, then what about the other case that you owe 213 on?
I thought I was only aware of one ticket.
You got two.
One for,
That's on the B file. I put that.
okay.
When you gonna pay that?
I just put another $50 towards that, everyone. Can I do 150 next weekend? And then just do it.
Here's what I'll do. You pay $80 bi-weekly. Beginning March the 19th. You seem like a nice kid. Why are you acting like this?
Just being irresponsible.
Well, that's good to hear somebody admit. Reduce balance by $40. So balance as of today on the A file will be 173. That's on the A file. So you're gonna pay $80 bi-weekly, beginning March the 19th, okay?
Okay,
You understand all that?
sir.
All right.
Appreciate it.
If you need more time, you call the court, we'll go on Zoom or come talk to me on or before the due date. I'll be glad to give you an extension. Good luck.
Thank you.
Thank you. Mr. Arietta, I can see you now.
Yes, I'm here now. Can you see me now?
Recalling Ronald Langlands versus Cars and Trucks Engines 4 less.
Would you like my account?
Yeah, you can bring him up, sure. Your name, Mr. Arietta?
Michael,
You got to tell me your whole name, sir.
Michael Ariet.
And Mr. Langland's your name.
I'm employed by Lands.
All right, so this is a small claims action, Mr. Arietta.
Yes,
And you actually have an A at the end of your name, correct?
it's a T at the end of the name.
Okay,
Oh,
so just Arietta, Ariet, right?
all right. Yes, sir.
All right, so listen. He's suing you for $7,000. He says you sold him a defective engine. You sold him the engine under the pretext that it was completely remanufactured and in working condition. That's what he says.
All right.
He says that this claim arose December the 19th, which is only obviously about 2 months ago. Before we go on, I need to tell both of you, you have the right to have the case removed to the General Civil Division. This is small claims. Plaintiff is capped at $7,000. If he spent $20,000, he could sue in small, or I'm sorry, he could sue in the General Civil Division if his damages amounted to $20,000, but he can't sue in small claims. Each one of you have the right to remove this case. If you stay in the small claims court, you're giving up certain rights. Each of you are giving up the right to hire a lawyer. Each of you are giving up the right to have a trial by jury. Each of you are giving up the right to appeal any decision that I make, no matter how bad you think it is. Plaintiff, to the extent that you're entitled to it, you're giving up the right to seek in excess of $7,000. Do you understand everything I said, Mr. Langland?
Yes, Your Honor.
Mr. Ariet?
Yes, I did.
Before we go on, I will tell you this. You don't have to give up those rights. If you want to, just tell me, Judge, I want to have the case removed to the General Civil Division, in which case you can appeal my decision if you don't like it. I'll still be the presiding judge. You can hire a lawyer. You can demand a trial by jury. And again, plaintiff could seek in excess of $7,000. You understand everything I just said, Mr. Langlands?
Yeah.
Mr. Ariet?
Yes,
Do you wish to give up those rights and proceed here, or do you wish to have the case removed to the General Civil Division, Mr. Langlands?
Proceed here.
You waive those rights?
I do.
Mr. Ariet, do you wish to proceed here, or do you wish to have the case removed to the General Civil Division?
I waive the rights.
I can't hear you.
No, I can. I will stay here.
You waive those rights then?
Yes, I waive the rights.
Sir, what is your name?
Henry Murad,
Is it M-O-R-A-D?
U-R-A-D.
All right, I'm going to ask all of you, and I'm going to have to see your hand, Mr. Ariet. I'm going to ask all of you to raise your right hands. You solemnly swear, affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Mr. Langlands,
I do.
Mr. Morad, Mr. Ariet.
I do.
All right, so put your hands down now. You're good. And now I need to hear why you think you're entitled to relief.
Well, the engine has,
What kind of car is this?
it's a 2010 Ford F-150.
Okay,
Needing an engine replacement. I purchased the engine from Cars and Trucks. The engine was sold under the pretext that it would be remanufactured in working order. The first thing after the engine was installed, they found it was out of time. So the entire engine had to come apart in the front and be put back in time. That was an additional $1,700.
that you paid to them?
No, to my mechanic.
Okay, so he sold you this and he had in the document that this was a remanufactured and in working condition engine, correct?
Correct.
All right, go ahead. Tell me what happened. You
So-
bought this back in December of 25, correct?
Correct.
December 19th of 25?
Correct. Yes.
All right, good.
We're on the 4th. So we had to.
Were you in Florida at
No,
the time?
we're here in Michigan.
All right. But he shipped it to you.
Correct. As these problems were arriving, I had Henry speak with their mechanic, Ernest. So we're.
Okay, let's slow down a little bit.
When the motor was found out of time,
Okay, when was that?
that was as soon as it was installed.
Who installed it?
A week after, Your Honor, we installed the engine. First, they sent the engine on pictures, it showed the engine's complete. And when upon arrival, Your Honor, it wasn't complete at all. It didn't have the valve covers, no front cover. No oil pan tube, pickup, nothing, not even a rear main seal was on there. So I contacted Mr. Ron and told him about it. He said, okay, it's fine, put new parts on, we put new parts. Started the car, it starts, runs fine. And
What
then
day is this? About a week
a
after?
week after, exactly.
So was it around Christmas? Well, you will,
Took a while to get the shipment in.
okay, when did the shipment arrive?
It's like 2 weeks after.
Well, you wrote the date the claim arose was December 19th. Is that the day that you agreed to purchase the engine?
Yes, it is.
And how long did it take for it to arrive?
About 2 weeks.
2 weeks.
So you're telling me, and I want to put words in your mouth, sometime the first week of January, the engine arrived.
That is correct.
And it was sent directly to Mr. Morad?
That is correct.
All right, go ahead.
Yeah, so it was
So it didn't have the valve covers, it didn't have the oil pan. What else didn't it have?
rear main seal. Oil pickup tube. And
Oil pickup tube?
yeah, the oil, it's a pickup tube that goes into the.
Pickup tube. Okay, I'm sorry.
TUB.
Okay,
So we.
do you agree with that? Mr. Ariett?
Okay, no, I don't. The
So
reason is,
you're saying it had the valve cover.
no. It doesn't have the valve cover, but.
Hang on one second. I want you to listen to me.
Yes,
He just told me the engine that was delivered didn't have the valve cover. Do you agree with that or disagree?
I agree with that.
It didn't have the oil pan.
I agree with that.
It didn't have the
Rear main seal.
rear main seal.
Not installed, but it came with the engine. I don't know if I can explain now or.
Not yet. I
have
just
to
want
wait.
you to
Okay,
answer my
okay,
questions.
Okay,
Are you saying that the rear main seal was sent?
no, it wasn't installed, but it came with the engine.
So it was sent to Mr. Morad's place of business?
With the gasket set, yes.
And what about the pickup? What'd you call it? Oil pickup tube?
Yes, sir.
What about that?
None of that was included in the deal.
Was or wasn't?
It wasn't included in the deal.
One.
Did you execute some contract with him or some documentation as to what he was to send?
Okay.
No, I was told a fully remanufactured engine on the internet, which I printed out, it shows.
Let me see it.
These aren't even things I'm claiming for. I'm just going for the labor and what I spent. So if you want to go past this section, I agreed to eat what wasn't there. So that's really the point for the case as far as the dollar amount portion of it.
Okay.
So if we'll make it simpler.
All right, good. Go ahead. So why don't I let you finish? And then you're going to be able to ask questions and you're going to be able to testify. Okay? Go ahead.
So, we called Mr. Ernest. He said the engine ran the first 10 minutes perfect. Then it started hesitating. It's throwing timing though. He said, that's his own words. He said that the timing, there's no way it might be off, but the phasers can be defective. I said, out of how many engines do you do that? He said, sometimes out of every 8 to 10, 8 of them will be good, 2 will be bad, some of them 9 will be good, 1 will be bad. But I never had any issues and stuff like that, but I'm willing to send you the VVT's phasers.
Put that in layman's terms.
So that's sprockets that the timing chain sits on,
Okay.
so the engine can rotate.
And he said he'd send you them.
Yeah, so he sent it 2 weeks later, he sent me 2 of them.
So now we're the end of probably middle third week of January.
Yeah, so after we took the front timing off, the cover, we're rotating the engine, and I can see the timing is off by a tooth. So we put it back, we sent him back all the VVTs, the sprockets. We did it, we turned it on, the car ran for 45 minutes to an hour, and then it started losing pressure.
Oil pressure.
I was like, okay, we turned it off, we called them, he wouldn't answer, he sent us to a different guy. And the other guy's like, yeah, you have to use 10W30. I said, hold on, the car takes 5W30. I'm a certified mechanic from the state of Michigan, and I'm a certified mechanic from Ford dealership. I worked there at Fairlane Ford for 7 years. There is no way if the car calls for 530, you put 10W30. He said, yeah, well, it's a new engine and you should put this. I said, let me talk to Ernest. He said, Ernest is busy right now.
Who? Who's Ernest?
The person I spoke with all the time.
Okay,
Thought he was an owner.
all right.
So we're like, okay, sounds good. He said, put 10W30. I said, are you guys gonna reimburse Mr. Ron about labor and stuff like that? Because this is not his fault. Now it's on you guys. They said, no, we're only responsible for the engine. I said, okay, the
If I
engine,
can-
you guys.
Hang on.
If I can object, the timing, the retiming that he had to do with pulling the whole front of the motor off after it was installed. So I had to pay for that. It's about $1,600. That was just gonna be, okay, go.
So we did what they asked us. I went and I turned on the truck. They told me to replace the VVT cylinders. I said, is he gonna pay for it or are you guys gonna pay for it? They said they might be defective, you gotta get them from Ford. I went, grabbed the rear main seal and the VVTs. We installed the VVTs, which is, it reads the oil pressure and the timing. So we replaced those. Same exact problem. The engine started losing oil pressure. So I put the oil pressure gauge onto the engine, connected it, and the gauge said 15 PSI. So after it runs for an hour, 45 minutes to an hour, the car starts to lose oil pressure. We called them again. I said, open a video call. Let me show you. Yeah, we're not gonna open a video call. I said, all right, who's gonna pay me what? They said, we're not responsible. I said, okay, that's fine. Call Mr. Ron and I told him.
So that's a rear main seal indicator.
How are you out $7,000?
Okay. Actually, more than 7. Summary.
Well, 4,200 was the original purchase. That included freight and $500 for exchange, which I have not yet received back, but I did ship. I have to bill a lady my core to them. Okay, 4,269 was my original purchase. The cars and trucks that included 2,900 for the motor itself, 570, I believe, for shipping, and a $500 core exchange. Then I had 5,000.
Hang on. Okay, 5,000 what?
$5,319 in labor for the original swap of the motor, the additional parts that had to go on. I also told him to put new exhaust manifolds on, which is not on them, and I've reduced that from this price, so they've been taken out, and I have the detail for everything here. So I spent an additional $5,319 for the original swap of the motor, and then the additional labor for pulling the front of the motor off and retiming everything and putting phasers on, or the sprockets for the timing here, which was no.
Where's the engine now?
The engine now, I have it in my storage unit. It's been pulled out. I had them get a good motor and put it in, took for another $9,000 now, but that's not part of this case. So I had to eventually get it resolved, almost 20 grand. I'm out $9,588 with zero to show for it with the original purchase, core exchange, freight, and labor.
All right. Mr. Area, do you have any
Okay.
questions of either Mr. Langland's or Mr. Murad?
Okay, first I wanted to explain that we're saying that the engine is a pre-tested engine. This is a remanufactured engine. All remanufactured engine, they do not include any of the covers or accessories that they mentioned. is not in the picture. That when he pushes the engine on a website, the website does not show any picture. The description of the website, I mean, show pictures, but doesn't show any of the accessories or covers that he mentioned. It doesn't come with it. It's not in the description or the picture when he pushes the engine. Okay. The engine is tested, but it's not an engine that you can run because
Sir, I need you to, so you got a little bit of an accent, which is fine. I just want you to slow down and keep your voice up a little bit more for me. Will you do that, please?
Yes, I can. Okay, like I
thank you.
said, there is no covers or accessories as per
I heard you
picture
say that.
of
None of those
description.
items
Okay.
come with it, you said, right?
No. It's not on pictures, not on description of the item that we were selling. All right. Now, yes.
Hang on. Hang on. Let me see your pictures and your breakdown of damage.
This is on their website.
And again, I'm not suing for any of this portion we're talking about.
I understand. All right, go ahead, sir.
So the wrap covers into all damage.
Go ahead.
Okay. Then on the warranty, yes, it does cover, if they have an issue. So we spoke with them in reference to the phasers. We send them the phasers. On the item description at the warranty section, it says that we do not cover any labor, but we were willing to work out with them on the labor. Okay.
Where's that warranty section? Do you have that?
I do.
Let me see it.
It does only cover parts. I don't see this as a warranty situation. I see it as a defective product shipped.
And the engines were not tested, and they made that clear. They only ran compression.
Give me 1 second. How much did you pay him again? The company?
42 with the shipping and the core exchange and the actual purchase of the motor, $4,269. My core has been returned to them. And you have to receive a $500 for reimbursement.
All right, go ahead, Mr. Elliott.
Okay. Like I said, our warranty covers the engine. Okay. And
It covers the engine.
the engine, yeah, parts in the engine, no labor. We've been doing this for 13 years. We sell a lot of engines online. And yes, we understand that sometimes stuff happens, and sometimes, yes, we do cover some labor. We don't have a problem with it. After we talked back and forth with them, I told them, look, you cannot solve the issue. So now it's time to send the engine back either for replacement or for a full refund. We had no issues with it. If you look at the bottom of the page, it tells you that we will replace the engin. That's what
Did
the
he tell you
warranty
that?
covers.
Did he ask you to, hang on, wait, did he,
Yeah.
hang on, let me ask the question.
When the problem.
Let me ask the question.
Yes.
Did he tell you, send back the engine for full refund?
No. He said, send back the engine for a replacement. And it was my responsibility to pay for all the labor to pull it out, which is about $2,000. And he would not agree to paying the freight to ship it back to Florida. He said, I have to pay the freight. So that was gonna put me out another $2,500 to ship him a motor back to get another.
And then, and pay for labor.
Yes, and that I'm not gonna trust. I don't want more from them. So
All right.
that was not an option for me.
All right, go ahead, Mr. Elliott.
No, we didn't ask to pay for the
Do you have anything in writing on that, or was that just a verbal
no,
communication?
that was over the phone. That
I'm
was
sorry?
over the
That was over the phone?
Yes.
Okay, go ahead, continue.
like I said, we're willing, if they already got another engine, we're willing to return all of the money, freight and
Wait a minute, you
everything.
gotta keep your voice up, sir. I'm having a hard time now.
Okay, I said that we are willing to return, give them a full refund for the engine and the shipping since the engine didn't work, but we don't cover labor. At the time of, the repair, we were willing to work it out with the labor, but we don't cover labor, or warranty says that we don't cover labor.
How much do you figure that you have? I'm just asking. I know you're throwing numbers out there. How much do you figure you have out of pocket excluding labor?
Well, we have $4,269 was the original purchase,
Right.
excluding labor.
It would be 4269, wouldn't it?
Would there be anything else?
That's just for the engine.
Yeah,
No.
that was the engine, that was a brake, that was core.
And then we had to do the timing again, and then yank out the engine.
I know, but that's labor, right?
Yeah, but they're responsible, because they sold something online that said it's been tested and it's Goodyear on it. And then for them to send somebody a part, it's not like a $500 thing. It's $4,269. If I'm gonna sell something for $4,000, I better make sure that I have the top-notch people working on that part to sell it. Because I bought the engine with labor, with 3 years warranty and unlimited mile, remand 0 mileage on it for 8,900 parts and labor. They should at least reimburse him for the timing, for the VBTs that I had to redo. Because he got charged for it, not them, and it's their
The
responsibility.
timing and the VBTs, how much labor did you, and whatever
It
else?
was like about 1,800, and then we found the oil pressure was bad, and then we had to take off the engine and replace it. I said, I'm not getting any more engines from them, because they were giving us a hard time. I let my first mechanic talk to them, because I was sick of talking to them. Because they will give the phone to someone, oh, here, talk to this guy, or here, talk to this guy. And then Ernest, there was
Okay,
always busy.
go ahead, Mr. Ariett. What
Okay.
else do you want to tell me? But get close to your device, slow and nice and loud.
Okay. On the part, okay, we send an engine, the part, yeah, like I said, the part might be defective. We send them a replacement part. Now, I don't know when they replace the part, if they did it the correct way or not, because I am not there. And I send them another part. I got receipts from where I bought the parts. We sell a lot of these engines, and we don't have those issues with those parts. I send them 2 of the same part, and they had the same exact issue 2 times. He also said when he started the engine, everything was running perfect for 10
For half
minutes.
an hour, 15 minutes on one occasion and 45 on another. Here's the point. Did you tell them that he had to pay for shipping, that Mr. Langland's had to pay for shipping to ship the engine back?
No, sir, no.
Did you
I didn't.
agree to pay for the shipping?
Yes, I did.
Is that true?
Absolutely not.
Do you have any documentation that tells me either that it is or isn't true?
I do not. But keep in mind, I would also have to pay to have the engine removed.
I got it.
Yes, but no, that I told them that I'm not gonna pay the freight.
And that would have been how much to have the engine removed and shipped? Did you say, did I hear 2,500?
Probably about 1,700 for the labor to see if I'm working with me, and then another 480.
So about 2,200? Yes?
Yes,
All right, what else, Mr. Ariett?
The book doesn't even pay that much money to for everything they're saying they did. You know, like the timing, $1,800. That's I'm not sure how much they're charging.
Are you a
for
certified
for
mechanic?
the rate. I am a certified mechanic for over 15 years, and we've been selling engines online for years now. It's not like we
But
started.
this one
yesterday.
clearly was defective. Don't you agree?
I agree that there was an issue with the engine, yeah, and we were willing to work it out. But I think they're just trying to charge a lot of extra money that doesn't balance with the hours that the system, like all data, Mitchell, requires to pay for that.
Hang on, you guys. Don't argue. No, please, no argue. Let them finish. Go ahead.
Yeah,
Finish.
that's what. That's what I was saying. You know, that's a lot of labor for what the book calls for. And like I said, they did replace the part, and the second part had the same issue. I cannot tell that, you know, that they did the correct thing or not. I have no idea. I have no. That's why I asked them to, you know, return the engine. And I was willing to work out a little bit with them on that, but
How much do you think it should have cost to have the engine removed?
I'm sorry.
Mr. Murad and Mr. Langlands here are telling me that would be about $1,700 in labor to remove the engine. Is that not what you said?
No,
And I go off of Mitchell.
Hang on. How much do you think it should have cost?
we charge about $1,000 to install and remove an engine.
Where is your shop located?
We're in Miami, Florida.
Cheaper in Miami than Trenton?
That's.
Okay,
Start sending them all my.
all right, no, don't, come on now. No. Mr. Ariett, what else would you like to tell me? Have I let you finish?
Like I said, you know, I'm willing to give them back all of the money on the engine, shipping and everything. Since, you know, we couldn't figure it out, but we need to pick up the engine and bring it back.
The only reason that the engine was, you would agree that there's no way for them to tell if the engine's working or not without installing it. And therefore, once they found out it was defective, they would have had to remove it, correct? You
Yeah,
agree,
but
right or not?
I agree, yes.
Just give me 1 second. Do you want the engine back?
Yes.
If you want his engine back, wonderful. I need my core back, I sent him.
Your what?
My core, see, my original core was sent to them as part of the agreement for $500. I was supposed to get back, and I never did.
So the original engine.
The original engine that came out of my truck, see, because when I had them put better engine in it, this was all after the fact. I wasn't able to give them core, because I didn't want to take this new engine that they had given me and turn it in for core until we had it really here, because they may want it back, so it's sitting in my storage unit. So if they want that back, then I need my core back that I shipped it out.
God.
I know it gets very crazy.
How much is the core? You said the cores are worth $500?
600 and 630 is my core exchange for this. If they don't want it, I'll give them. I can give the core. If they don't want to swap all these motors, they can keep my old core. I can give them the motor that doesn't work as a core for the company that.
We got the engine.
Makes no difference to me.
What do you want to do? You hear what they're saying, Mr. Ariett?
On the core, I might be able to send the core back. I can send them straight to whoever they bought the engine from.
How much will it cost you to send the core back?
Probably somewhere around, hold on, I can tell you.
Well, why
Yeah,
would that make any sense for him to be shipping back a core? I mean, unless somebody wants to profit by $50. If it's gonna cost $450 to send back and it's only worth $5 or $6, right? So does that make any sense to anybody? It doesn't to me.
It will cost me $250 to send the core back.
They charged me $570.
Who did?
per ship.
Okay, 570 is for both ways. The
That was-
core is $250 one way.
Actually have a bill of lading for a ship like all that. I don't know if it doesn't have a price on it, but they charged me $570, which was for them to ship the motor up and 50% of the freight to ship it back. So a one-way ticket's around $400.
Have I let Mr. Langlands, have I let you finish? Have I let you finish? Is there anything else you want to tell me?
Yeah, the only thing I'd like to add is when they were discussing the parts that were static. When the motor was out of time,
My mechanics were trying to explain to them, it's out of time. They said, no, it's these two sprockets called phasers where the timing chain goes around. We'll send you new ones from Ford's overnight. Took 2 weeks to get them and the sticker right on it said made in China. Another thing. My mechanic was telling me that it's out of time. It's not these sprockets, but since you're willing to claim that is, then we'll put them on. So they put the new sprockets on. That's when they determined that one phaser was one link off on the chain, which is way enough to throw a motor at a time. So the sprockets that they sent me, which he claimed might have been installed improperly, there's only one way for the sprockets to go on. The motor was out of time because it was off by 1 tooth on the timing chain. The other thing is the oil pressure situation. Henry mentioned went down 15 pounds. It was actually, when it warmed up at idle, it was at 5 pounds. So indicating, main bearings. And I agree with the shipping back and forth is ridiculous, and I'm not talking in much difference in just giving everybody the course.
All right. What else do you want to say, Mr. Area? Anything else? Did I let you finish or do you want to tell me something else?
Yes, he's saying that the engine was out of timing, but at the beginning, he says the engine worked for 15 minutes, perfectly fine. An engine out of timing does not perform well at no time. It doesn't perform well at all.
Mr. Moran?
When you started the car, until the oil reaches everywhere and gets lubricated inside the engine, it takes 5 to 10 minutes, everything, and it was misfiring and shaking. I looked at it, cleared the codes, it ran for like about an additional 3-4 minutes good, and then the timing codes started coming on. And for him to say it might be off, I go off of Mitchell again, and I'm Ford certified mechanic for 7 years. There's no way for you to do the timing wrong. There's 2 arrows at the top, Your Honor, and it shows you on the chain where to put them and how to connect them. And then there's a small pin in the back of the phaser you just flip onto the camshafts. There is no way for you to put them on wrong. I don't know what he's claiming or who's what, but if I was you, to be honest with you, I'll look at every single engine that I'm gonna sell before I start talking and throwing things at other people.
Okay.
Because you guys didn't do the.
Okay. All right. Okay. Anything else, Mr. Area?
Like I said, he said at the beginning that the engine, he was the one that said it, that the engine ran fine for 15 minutes. So I don't think it's a timing issue. That's why we send them the phasers. And like I said, I never had that much problem with the phasers. Every once in a while, but not like that.
– 15 minutes was the oil pressure problem, not the timing. That was the idiot.
And they decided, Your Honor, that it needs space.
All right. Mr. Ariett, I'm sorry, I disagree with you. You can't sell an engine like this that's defective like this and get out of the labor costs by pointing out that there's no labor reimbursement. The fact is that as a result of this defective engine, he had to expend labor in order to take the engine out, period. I'm going to rule in favor of the plaintiff. I'm going to give the plaintiff $7,000 plus $70 and $12, $7,082. You are to retain the engine for 1 year. If defendant pays the judgment in full, then he is entitled to have the engine shipped, the old engine shipped back to him, but you have to pay for the shipping, Mr. Ariett. I'm not getting into the core. You can keep the core, but you're going to pay $7,000. He's going to take this for 1 year. He's going to keep that old engine for 1 year. It shouldn't take you 1 year to pay this. I'm going to ask you to pay it right now. But if you pay that and you can communicate with him that you want to pay for the shipping and that he's You're to make arrangements directly with Mr. Langlands. If there's a problem, you can file a show cause. If Mr. Langlands doesn't agree to do that, he's gonna have a big problem with me. Can you pay this judgment today?
No,
When can you pay this judgment?
I don't agree completely that I have to pay $7,000.
Listen. I'm not gonna argue with you. When can you pay this judgment?
1 year.
No.
You say I have a year, so
No,
need
I
a
did
year.
not say that you had a year. I said I'm ordering him to retain the old engine for at least a year.
When you said the old engine, you mean the engine that we send in, my
Yes, the
engine, the
engine
one
that
he
you
has?
sent him. He's gonna have to retain that for 1 year, and when you pay this judgment in full, he's going to send it to you once you make arrangements to pay for the shipping and get a hold of him. If I'm just telling you that if you don't pay the judgment, let me put it to you this way. He can dispose of that engine in 1 year, and I'm not gonna care. He's not required to act as a bailee here or anything else in terms of that engine. I'm telling him he's going to retain the engine for 1 year. If you pay this judgment today and you make arrangements with him to ship the engine back at your expense, then he's to do it. Do you understand that?
Okay, so he's gonna keep the engine for a year, even if I pay today.
No. I'm not making myself clear. You pay today, you guys get on the phone today, and he's sending you the engine back, but you're paying for the shipping.
Okay, I need to make arrangement to make that payment. I don't have that amount of money right now.
How much do you have that you could pay him today?
How am I gonna pay him? I can send him a check, but I don't.
Can you send him a check for the whole thing?
No, I don't have that amount of money to send right now.
Well, tell me what you can pay and we'll set up a payment plan here.
I can pay $1,000 a month.
Is that acceptable? Defendant must pay the judgment to plaintiff in installments of $1,000 monthly starting March the 15th, okay?
Will that go through the courts, Your Honor?
No, he's gonna have to pay you direct.
We don't communicate well.
Well, you're gonna have to pay him, Jennifer, I need another judgment printed out, please.
Yes,
I
Judge.
wanna get. Okay. You're gonna pay, did you want to say something, Jennifer? Was that you?
I'm printing it now, Judge.
Thank you. Listen to me, Mr. Area. You have to have him a check to this address that's on the judgment, 4080 Ponderosa, 4080 Ponderosa in Trenton, PONDEROSA, that's 4080 Ponderosa, 4080 Ponderosa, Trenton, TRENTON, Michigan, 48183. Do you understand that?
Yes.
So you guys don't need to communicate except when he satisfies the judgment.
Okay, and when
And
do
then
I
I
pick up
expect
the
you to do
engine?
that. Pardon me?
And when do I pick up the engine?
You're gonna pick up the engine as soon as you paid this in full.
Okay, are they gonna keep the engine covered and safe? Because that's a new engine. It's just one part that is defective, but that's a new engine.
Stored inside of storage unit on 4th Street. So it's kept out of the weather.
Okay? I can only referee so much of this. I don't think he's gonna be silly enough to defy in a court order. When I say retain it, I don't mean throw it in the Detroit River. I mean for him to retain it in a safe condition where the engine can be utilized once you receive it.
Okay, so it's gonna be covered and everything. Okay, perfect.
And you got it covered, right?
Yeah, we have the issue now, though.
Wait,
Yes, it is covered. It's inside.
Inside is not covered. It's a new engine, so it needs to be covered.
it needs to be covered. Is it covered?
I can put a cover over it.
He'll put a cover over it.
Now I don't have the board to give it back to
the people that I got the second engine from. So I'm out to 600 and
I can't do it.
I'm good. I'm good.
I can't do anymore. I'm gonna hand you back.
They can have this back if they want anytime they want. It's really about the way.
Here, I'm gonna hand you these documents back.
But
I need to rewrite this because there's a lot involved here. I expect you guys to deal with each other like gentlemen. Okay? You make sure you retain that. You make sure you preserve that. You put a cover over it. And you make sure that you make your payments as you're supposed to, Mr. Elliott. If not, he can come down there with a lawyer and they can start garnishing and executing on property. You don't want that, okay? You understand what I'm telling you, sir?
Yes, I do.
Okay, I have to rewrite this on a break. There's too much involved here. I'll keep this. You don't have to wait around. When I get a chance today, I will fill out the judgment. We'll send it to both of you. Do we fully understand the judgment?
yes, Your Honor.
Do you fully understand the judgment, Mr. Elliott?
Yes.
You pay them as soon as you can, you're gonna get that engine back.
So
Okay,
it's $1,000 every 15th.
yes, of every month, starting March 15th.
Okay.
Good
Thank
luck.
you.
Thank you.
Thank you, Your Honor.
We're gonna take also pictures of it covered and email it.
Yeah, that's good. Thank you. I thought you were honest, Mr. Murad. Sean Michael Will, and you too, Mr. Langland. Sean Michael Wilson, the second, 23B 143763.
Good morning, Judge Mazingate, on behalf of Mr. Wilson.
Do I have anybody out there on the felony or whatever I have, John? Or whatever is there an in custody you said?
No,
Okay, good. Let me know. Your name?
Sean Wilson.
Why are people showing up again 3 years, 2 years late? Can somebody tell me?
Judge, Mr. Wilson had some home residency issues. He was bouncing around from address to address, so he did not have to live, stay living.
Does he stand mute and wait formal reading? Not guilty, please, entered. I hope he has some money with him. Where does he work? Why not?
My license.
What do you have to take care of to get your license? And why did you wait till?
I also had a job.
When did you last work? I hope you have $100 with you. You have 100 with you, right?
Sir, are you a father?
Yes.
$100 cash. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I will set this for a pretrial on March the 19th, and that will be at 8:45 in the morning. Okay, so you're gonna have to post $100, and then you come back in here on March the 19th. We'll give you a court notice down the hall. And if you want a court-appointed lawyer going forward, you'll have to fill out a petition for one, okay? He'll hand that to you and sign, and you can fill it out now and hand it back to my court officer, all right? Show up in court. Good luck. DVC America LLC versus William Wayne Porter.
You don't want to vote for the meetings. You don't want to vote for the.
Are you guys, what's your name?
Yes or no?
Yes.
Are you the president of the DVC?
Yes.
Guys, can you please keep it down? Thank you. Guys, can you please keep it down over there? Thanks. Wait a minute, slow down. I didn't catch your name. I'm sorry.
Matthew Whitby,
Whitby,
WIDBY.
and your position with DVC of America LLC is what? Okay. This is a small claims action. William Porter was hired to install new furnace and AC. He purchased most equipment, then refused to do anything until I gave him $12,000 for labor up front. I gave him $12,000 already, of which he spent $8,000 approximately. Do you guys have any interest in sitting down with one another and trying to resolve this?
Absolutely.
You want to do that? All right, listen, let's put feelings aside, personalities aside. Why don't you two go into a room and see what you can work out? I'll put the file right here. When I see you come in, you're gonna tell one of you, are gonna tell my court officer we resolved it, or we need to go to a hearing, okay? My court officer will tell you where to go to a, well, they can go right to a conference room. Okay, thanks. LVNV versus Jasmine McDaniel, 2505258.
Morning, Your Honor. Preston Nate, P77884, appearing for LVNV.
Wait a minute. Okay, I got you there, Mr. Nate.
Yes,
Good.
apologies, Your Honor. Sonny Miller, P88410, on behalf of Jasmine McDaniel.
All right. Morning, Chief.
Sir, how are you?
Good, you? All right. You guys resolve this?
We haven't yet. I think if we could just grab some dates, we'll continue to work on it.
Okay. All right, I just need you a little, Mr. Nate, you're 77884.
Correct.
Ms. Miller, what is yours again?
88410.
Too bad you weren't in the Olympics. You got that name, you could have had all kinds of endorsements, you know?
Yeah, it would have been great.
So you guys want discovery? I can do the same thing. I think I gave you April 24th on the other case that you were in front of me on, Mr. Nate. I'll give you guys, nobody demanded a jury, correct?
Correct.
That's correct. Yes.
I don't usually ask that on these, but I had somebody do that recently and then I had to call them back. Witness list due March the 24th. Discovery cutoff April 24th. No settlement conference. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. Trial date will be on, what date did you give me? May 18th, Jennifer, at 10:30?
Yes, Your Honor, May 18th.
At 10:30 will be the trial date on this. We will send this out. Again, no motions date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Anything else, Mr. Nate?
For this one, no, Your Honor. Thank you.
Ms. Miller? Here
No,
you
Your
go.
Honor. Thank you very much.
Okay, thank you very much. Have a good day. LVNV versus, do you need this, Sadie?
Yes.
LVNV versus Valerie Brown, 2505278. Same thing, guys, your appearances?
Thank you, Your Honor. Preston Nate, P77884 for LVNV.
And Sonny Miller, P88410, on behalf of Valerie Brown.
I'll do the same thing as the last one. Discovery cutoff April 24th, May 18th, 10:30 trial, and March 24th of this year. Witness list due, same thing. I'll send this out unless somebody has an objection and they want more time or less time. Anybody, Mr. Nate?
No, that's perfect. Thank you.
Ms. Miller?
No objections. Thank you, Your Honor.
All right, thank you very much. We'll send that one out. Here you go. I'm not even gonna write all this up. It's the same. Well, LVNV versus William Henderson, 2505274.
Morning, Your Honor. Preston Nate, P77884, appearing for LVNV.
Good morning, Your Honor. Diana Xagaravas appearing for Trevor Cruz on behalf of the defendant, P32106.
All right. Good morning, Ms. Zagorowski. Give me 1 second here. Oh. What's your P number, Ms. Zagorowski?
32106.
Geez.
I know.
Well, you're even lower than me, and that's kind of hard to do.
Well, what you want to know something really funny? I called the state bar and I was asking, they have no record of when I was sworn in or dates or nothing. I needed some info and they don't have it.
Well, you should have been sworn in 81 probably, right? If,
January of, yeah, 81. But
I
it's funny,
mean-
they don't have it on their record. She couldn't get it. She didn't have it. She said, if you tell me what it is, I can write your letter.
that's because, we're fossils, we're dinosaurs. They don't
Ain't
keep
that the
records. Guys, I could do this for you unless nobody resolved this, right?
Actually, this one is resolved. I did get a consent judgment signed from the opposing counsel yesterday, so I'll just get that submitted to the court. That should wrap it up.
Okay, good enough. Saved us some work. Thank you. So I'll wait for you guys to send in the consent, hopefully the next day or so, and have a great day. Anything else, Ms. Edwards?
Nothing further.
Thank you very much. Have a great day, everybody.
Thank you. Thanks, Buzz.
Let's see here. I have Crown Asset versus Ian Adams, 2502599.
Good morning, Your Honor. Jay Baig, BAIG, our number P36820 on behalf of Crown Asset.
Good morning, Mr. Begg. How are you?
Good. How are you? See, there's another attorney with lower bar number than you and me.
Yeah, no, it's amazing. Is Ian Adams here? Or somebody for Ian Adams? Jennifer, they're not here, are they?
No, Your Honor.
Counsel, I'll give you a default. You can go ahead and give me your breakdown if you will, and we'll do a default judgment.
Okay, let's see if I have a
For the record, it
breakdown.
was scheduled for 9:30 and it's now 9:52. I give everybody at least 15 minutes.
Right. Damages $12,095.41. I don't have the cost information and statutory attorney fee.
You have a filing fee of 160. You have statutory attorney fee of 75. Are there any other costs? You did, I see there's a motion for second summons, so you're entitled to that $20 fee. And then it looks like another M filing fee paid of $20. So you should have 180, 275 plus the 12,095.41. So correct me, it should be 12,370.41. Is that accurate?
That sounds just about right, Your Honor. So we'll go ahead and submit a default judgment via my file then?
Yes, yes. You can file it right with Jennifer, give him the.
If it's the my file, it'll come right to us once he does that.
Okay.
Right. Oh, all right. Thank you, Your Honor. I do have one more Synchrony versus Epperson.
I'm calling that next. All right.
Thank you.
Thank you very much. How you doing?
How are you?
What are you looking for?
Wilson home?
John Wilson.
Did you just do it?
Yeah, I did. 8 minutes ago, probably.
Yeah, we're waiting for the file.
All right, Synchrony versus Lois Epperson, 2503153. Is Lois Epperson here?
No, Your
Jennifer?
Honor, defendant has not checked in.
You can go ahead and take a default, counsel.
Your Honor, this was a motion for summary judgment.
Yeah.
We would request that the motion be granted. She didn't file a response and we submitted.
I'm gonna find that there's no genuine issue as to any material fact. Motion for summary disposition granted. Defendant failed to appear, failed to file a response. Let's do this same thing on this one. You got 4195.26.
I have the information on this one, 4195.26. Cost $161.50, consisting of a $75 filing fee, $20 motion fee, service fee of $66.50, statutory attorney fee of $75 for a total of $4,506.76, Your Honor.
Thank you very much. You can submit your judgment. I'm granting your motion for summary. Judgment will enter in the amount of 4506.76. Thank you very much.
Thank you. Thank you, Judge.
NCB Management versus Ronald Reed, 25044 8040.
Yes, good morning, Your Honor. David Bader, representing the plaintiff, P67307.
Good morning. Good morning, Mr. Syed. Your appearance?
Good morning, Your Honor. James Syed, P80407, on behalf of the defendant Ronald Reed.
We've adjourned the party, this pretrial, a couple parties below, let's see, believe they have settlement. Isn't that what I wrote? I can't read my own writing sometimes. Did you guys think you had a settlement?
We had preliminary settlement discussions. We thought we were pretty close. I think we were just been having a hard time connecting with our client for the proper authorizations through the debt settlement company. Plaintiff's counsel and I had a chance to speak this morning. We think maybe if we get a scheduling order, we'll be able to get things wrapped up.
All right. I hate the bash settlement companies. Am I the only judge that has debt settlement companies? Am I the only judge that has a hard time with them? I mean, it takes forever. Nobody wants to answer me, huh? Okay.
I plead the fifth.
Mr. Syed, you're 80407. Mr. Bader, what is your P number, sir?
P67307.
673.
You're making me look. I'm in a few states. P67307. Yes.
Okay. I'm going to do the same thing on this one, Jennifer. Discovery cutoff will be April 24th. No motions date of trial. Nobody demanded a jury. Trial date will be May the 18th at 8:30 in the morning. And estimated time for trial, I'm putting down 1/2 hour. Witness lists are due March the 24th of 26. No trial brief necessary. We're not going to have a settlement conference, obviously, so I'll send this out. You guys will get it and set it for trial on May the 18th. Anything else, Mr. Syed?
Nothing for our defender, Your Honor. Thank you.
Mr. Bader, anything else?
That'll be it, Judge.
Have a great
And
day.
Judge, that's 10:30 to be the same with the rest
What
of
did I
them, right?
say?
I think
What
you
did I
might have
say?
said 8:30, but
Oh, it's 10:30?
10:30.
My mistake. Sorry, guys. 10:30. Yeah, I
No.
did say 8:30. My mistake. 10:30 in the morning. Okay.
Okay, thank you.
Your Honor.
Thank you both. Citibank
Bye-bye.
versus, here you go. Yes, I'm sorry. Citibank versus Robin L. Nickrand, 2505159.
Good morning, Your Honor. Again, Preston Nate, P77884, appearing for Citibank.
Morning.
Good morning, Your Honor. Gary Epps, P046306, subbing on behalf of Jeff Horowitz for the defendant.
All right, give me 1 second again. And that's 77884. No resolution, guys?
Not quite yet, so just the same scheduling dates will be fine, and we'll keep working on it.
Do the same thing. Discovery cutoff, April 24th. Witness list due March the 24th. No settlement conference, no jury trial. May the 18th at 10:30. May the 18th at 10:30 will be the jury trial, bench trial date. May the 18th at 10:30 a.m. And I'll put down 1/2 hour. No necessity to file a trial brief. If you want to, you can file and exchange it not later than 7 days before the trial date. Anything else, Mr. Epps?
No, sir, but you mentioned bar numbers. They're adding a 0 to our numbers to make room for the 100,000th lawyer soon.
Yeah, I think you told me that. That's interesting.
I've had some notices to appear where the 0 is on and some where it's not, but so we're being decimated one way or another.
Yeah. Have a good day, you guys. We'll send this
Thank you.
out. Thank you very much.
Thank you, everybody. Thank you,
Bye
Preston.
now. Here you go.
Yeah, thank you, Your Honor. I appreciate it. Thanks, Gary.
All right. Do I have here Asia Shia Lynn Abston,
Abston.
25T646293, your name?
Asia Abston.
You were supposed to pay the balance by February 6th. You didn't pay and you didn't show up. Why?
I didn't, I paid 140 and I didn't have the rest of it. I was hoping that I would have it by the end of the week and I didn't. So that's why I'm calling to see if I could
When
just
can you
finish
have the
paying.
balance?
It
When
was
can you have
the balance I have is 97.
Yeah, I know. When can you have that?
The 6th, when I get paid.
Plan to pay the balance by March the 6th.
Yep, complete.
I'll reduce your balance, trusting you're gonna pay. Balance reduced to $80. Okay?
Thank you. Thank
So
you,
I'll
sir.
reduce that and you pay that by March the 6th. All right?
Alrighty.
Best of luck.
Thank you.
Is Virginia, you're welcome. Virginia Ann Swindle here. Tracy Linville here.
Yep.
Where have you been?
Judge, if I may,
Wait a-
Mr. Dillard, can you join the breakout room,
Wait,
please?
wait a minute. I need Virginia Swindle here. I know, it's 10 o'clock. Just wait 1 second. I'll be right with you. Brook Gorham versus Eastern Account Systems of Connecticut, Inc., 2504915.
Judge, I don't have defendant here yet. I believe they had requested to appear by Zoom, possibly.
That's set for 10. So why don't you just hold on and I will be back with you, okay? City of Dearborn versus Urban LeBlanc,
They are in the breakout room. They're set for 10.
okay? How about Absolute Resolutions versus Tiffany Holly? Are they here?
I have Ms. Holly. I don't have plaintiff's counsel yet.
We'll take a 5-minute recess then. I have nothing else here ready to go. So everybody stay seated. I'll be out in a couple minutes. Thank you.
Judge, as far as John Borden, we have no objection to the adjournment. I think if the court agrees, we schedule it for the 24th. I would ask the prosecutor if they can give us some verification that I believe Mr. Markham's in the hospital.
And I'll have the victim advocate reach out and try and get that paperwork. That's not as soon as possible.
So we don't. So there's no verification that he's in the hospital?
I have not received any sort of documentation of the victim advocate. The victim reached out, said that he's in the hospital and that he would like to be here, but unfortunately cannot.
Well, I think if it were the other way around, I'd need verification prior to adjourning it. So fair's fair. So somebody get some verification to me. How soon can they get the verification?
Immediately.
Then folks, you're gonna have to have a seat because I'm gonna do something else if they don't have the verification.
That's fine.
Thank you, Judge. That's it. So I did one Portuguese interpreter and 2 cases that I did nothing. All right, good start. Ready on anything else?
We could call Bear Chatain, I think.
Or does call the case People versus Amanda Barrett Chatain.
Your Honor, read for the people.
Michael Getty, Assistant Public Defender on behalf of Ms. Barrett Chatain, who's approaching judge. State your name, ma'am.
Amanda Barrett Chatain.
Your Honor, this is the day and time set for preliminary examination. People are unable to proceed.
We'd move to dismiss, Judge.
People being unable to proceed, this case is dismissed on the defendant's motion.
Thank you, Your Honor. Have a blessed day.
You do the same, ma'am.
Thank you, Your Honor.
Your Honor, I believe we're also ready on Nicole Nielsen.
Which one?
Nicole Nielsen.
Nielsen? Court calls the case People versus Nicole Nielsen.
Good morning, Your Honor. Assistant Public Defender Davy Lieb on behalf of Ms. Nielsen, who stands to my right. Ms. Nielsen, can you please tell the judge your name?
Nicole Nielsen.
Your Honor, this is the day and time set for preliminary examination. The people are unable to proceed.
Your Honor, the defense would move to dismiss this time.
People being unable to proceed, this case is dismissed. That's on the defendant's motion without prejudice.
Thank you.
Thank you. Take care.
What's wrong? Huh? It was okay. It's very nicely done and just.
Your Honor, I believe we're also ready on Sierra Tackett.
Court calls the case People versus Sierra Tackett.
Morning, Your Honor. Raymond Cook for the people.
Good morning, all. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Tackett. Would you please state your name, ma'am? Sierra Tackett.
Thank you.
Your Honor, this is the time set for preliminary examination. At this time, people are unable to proceed.
We'd move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice on defendant's part.
Thank you, Your Honor.
Thank you.
Thank you. Have a good one.
You're ready on any of yours, Ms. Linda, or no?
I am ready, however, other councils are not here. Yes.
Who?
So, I don't think Mr. Warren Green for the PD's office on Dayton County, so that's a good name.
Mr. Who?
Green. He might be sure.
Where's Mr. Warren Green? Thank you, Mr. Green. Who else were you looking for? Just Sam?
Mr. Burdell, and then Mr. Johnson, I know is not here yet. Mr. Burdell is next.
What's he doing next door? Are they quick matters?
Yes.
Then get Verdell and Green, get them in here.
Judge, I'll go over there.
Court does call the case People versus Jesse De La Garza.
Good morning, Your Honor. Alex Warren Green on behalf of Mr. De La Garza.
Your name, sir?
Jesse De La Garza.
And Your Honor, at this, today's date, time set for preliminary examination, at this time, it's count one for unable to proceed, ask for count two to be remanded down to the court.
And Your Honor, the defense would move to dismiss with respect to count one.
People being unable to proceed on count one is dismissed. I'll continue to defendant's not guilty plea as to count two. And I'll set a pretrial date and 14B for
March 16th at 9 a.m.
March 16th, 2026, 9 a.m. before Judge Washington.
Thank you.
Thank you, Your Honor.
Thank you, Bond. Will continue. Thank you. Court calls the case People versus Charles Cobb.
Morning, Honor. Raymond Cook.
Morning, Judge Cobb, on behalf of Mr. Cobb.
Your name?
Please take your name for the record. Charles Cobb. And Your Honor, so previously I'd spoken to the prosecutor. I was not expecting this exam to proceed. It's my understanding the complainant is now present. I still need to execute a waiver form. We do intend to waive this exam.
All right. Is that correct, sir?
That is correct. That we're intending to waive the exam. Yes.
Yes. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Can you repeat that?
You understand that a preliminary examination is a proceeding where the people would have to show by the standard probable cause that the offense was committed and that you committed it.
What does that mean? Well,
have you guys talked about a waiver?
Yes, Judge. So this is basically, we talked about how the people have to present their evidence, and if there's a low standard of evidence, it will be bound over to circuit court. And you understand that you're waiving that hearing, correct? Yes. Okay, and we talked about this? Yes, we have. Okay. Do that satisfies that question from the court, Judge?
Well, I don't know that it does. Do you understand that what a preliminary examination is, sir?
Not really.
Huh?
I'm
gonna pass it. You'll explain to him what it is and what he's waiving. People can't come up here and waive their rights and not know. Bye.
Thank you, Judge.
Court calls the case, People versus Anthony Hamilton.
Robert Eggleston is here appearing for the prosecution of aggravated. But
Morning, Judge, your staff, Robert Burton Harris on behalf of Mr. Anthony Hamilton, who's also present.
Your name, sir?
Yes, sir, Anthony Hamilton.
All right, what are we doing?
Judge, after speaking with my client about this matter, he has decided to waive his right to the preliminary examination and proceed to circuit court on this. So, sign right here. And Mr. Hamilton is executing the waiver of exam form.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
I understand, Your Honor.
All right. People also waive their right?
yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with count two following.
Thank you, Judge.
You just gonna leave?
No, sir. No, I
Really?
was gonna talk to Ms. Wilder.
He's just gonna walk, he's just gonna walk out.
I was gonna talk to Ms. Wilder and then I'll talk.
What? You're gonna do what?
I was gonna talk to your staff.
Why?
Because
you gotta talk to me.
we got a lot to talk about.
Bert Harris. Everybody's just trying to mess up my day. You acknowledge receipt of the information?
Yes, sir. Acknowledge receipt of it, Judge.
You waive it,
waive formal reading of the.
And you
the
stand
felony
mute.
information, and we stand mute.
Yeah, all right. Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for
April 16th at 1:30 with Judge Slay.
April 16, 2026, 1:30 before Judge Slay.
Sorry, Judge, I always forget how efficient this court is.
I don't know if that was a compliment or not.
I was serious.
Bond will continue. All righty, thank you, sir. Set the waiver.
Thank you, Your Honor.
Oh, I got you.
Take care, Mr. Burton. All right. So we have no prosecutors. Might be real quick then. Where'd they go? They just.
Mr. Cook, who is speaking to the victim on one matter, Mr. Chalowski.
Oh, Miss Enda's here.
Is missing. Oh, Mr. Warren Green's here.
Do you have another one that's ready or? You don't know? Okay, well.
Yes, and it should be a waiver.
We already have Mr. Plus.
Oh, okay. You got it. Thank you. Anna's calling.
What?
Thank you, Your Honor.
Your name, sir?
Derek White.
And Your Honor, it's my understanding today that Mr. White is going to be waiving up the circuit court on counts 1 and 2, count 3 and 4 will be dismissed.
And Your Honor, the people did extend that waiver agreement. I think in addition to dismissing the 2 counts the people stated, the people would not object to a bond modification for home confinement. But if I may address that when appropriate, Mr. White does wish to preliminary exam. He's signing a form right now.
So you're waiving your right to a preliminary examination on counts 1 and 2?
Correct.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant standing mute to those charges. Court will enter a not guilty plea. Pretrial will be set for
March 9th at 1:30 with Judge McNally.
March 9th, 2026, 1:30 before Judge McNally.
Your Honor, maybe a protest.
Yes. Counts 3 and 4 are just.
Thank you, Your Honor.
Defendant's bond to a $10,000 personal recognizance bond. Defendant must be placed on a home confinement BPS tether prior to his release. I am also going to include, there is already 2613 Airwood Trail, which is an excluded address. I am also going to include 2490 Airwood Trail as an excluded address. There is another address, which is the complainant's address. Your counsel will tell you about that, but I am also adding that to the exclusion zone. All right.
Thank you, Your Honor.
Thank you.
Thank you. Yeah.
A no-go, a no-go too. So. This one's already one. 490 Airwood Trail is an addition. This is also an addition.
Those two are additional. Perfect. Thank you, sir.
Yeah. Court calls the case, the People versus Mamie Sar.
Alex Chavalowski for the people.
Morning, Your Honor. Dan Garrett on behalf of Ms. Sar. She's stepping forward.
Garrett.
Good morning. My name is Penda Sar.
May we approach very briefly?
Yeah.
Thank you. I realize everyone's doing.
People versus Charles Cobb.
So recall.
Yes.
Covered on behalf of Mr. Cobb.
Charles Cobb. Who was this? You could do the waiver. I just need, all right, thank you. Mr. Cobb, you had an opportunity to speak with your attorney
Yes, I have.
about a preliminary examination waiver?
Yes.
All right, I'm gonna ask you basically the same questions. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that by waiving that proceeding, you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right, people also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Burdette.
Waive formal reading, stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 16th at 1:30 with Judge Slay.
April 16, 2026, 1:30, Judge Slay.
Your Honor, may I approach to sign information?
Yes, bond will continue. Thank you, sir. Yeah, we do that one. That's called the case People versus Samira Danpolio.
Allison, on behalf of people, Your Honor.
On behalf of Ms. Gamble. Sorry. Please state your name for the record.
Thank you.
And Your Honor, today's the date and time set for preliminary examination. At this time, as to count one, the people are unable to proceed. The people would ask for count two to be remanded down to district court.
Your defense would ask that the case be dismissed. However, understand it's up to the people.
Continue to defendant's not guilty plea to count two. Count one is dismissed, people being unable to proceed. Pretrial in this matter will be set
March 12th at 10:30.
March 12, 2026, 10:30,
Yes.
before Judge Fresh Hour.
Thank you, Judge.
Thank you.
Bond continued.
Thank you. Talk to you about it.
How many more do I have?
You got 2, 3 recalls.
We can do if the defense attorneys are here on the all that.
Yes.
Court does call the case People versus Kwan White.
Mr. Chablowski is the prosecutor on this matter, Your Honor. I've called in, Michael Gaddy, Assistant Public Defender for Mr. White. I've called in the hallway, I've emailed, I've called in the other courtroom, and in this courtroom, I don't have any explanation as to his whereabouts.
Ring for the people standing in for Mr. Chablowski.
Kwan White, no response. Bench warrant will issue for the defendant's failure to appear. Bond in this matter will be set in the amount of $25,000 cash surety.
951. Present before the court is Ms. Santana, right?
Make sure you answer out loud.
Yes.
Represented by
Yes,
Mr.
Your
Brenner.
Honor.
We have Mr. Harrison, the prosecutor's office, and Officer Martinez from probation. We're here today, Ms. Santana, because your attorney has filed a motion requesting something called intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge. But instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes outpatient treatment. Essentially, you're going to keep doing what you're doing. You're going to refrain from the use of illegal drugs and alcohol, and you're going to complete this treatment plan. If you do all of these things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand all of that?
I didn't hear him. I have problem hearing.
Oh, let's get her the listening devices.
Do we need the?
Yeah, because I can't hear through the scare.
Okay.
I'm having a hard time.
Okay.
Yeah.
We'll get you
Yeah. Okay.
headphones here.
Yeah. Okay. That's what I'm trying to leave. Read his lips.
Testing, 1, 2, 3.
Thank you so much.
Thanks, Brett.
Try this right now. Wait a minute. I want to do this right. You know. Okay, now.
Can you hear me now? Is
Yes.
this better?
Yes. Yes.
Okay, let me start over again. We're here today, Ms. Santana, because your attorney has filed a motion requesting something called intervention in lieu of conviction.
Right.
We abbreviate this as ILC.
Right.
If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge.
Yes.
But instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes outpatient treatment. You're going to follow the rules. You're going to obtain an additional assessment, take your medicine as ordered. And if you do all of those things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes.
One of the issues that we have, Ms. Santana, is we've had a couple of discussions about this in pretrial, and I have been told that you say that you didn't do this. The ILC program, Ms. Santana, is not for innocent people.
Okay.
It is for people who did the things that they say they did.
Yeah.
Now, the Supreme Court tells me that you have the right, the constitutional right, to plead guilty to criminal charges, whether you did them or not. That's called an Alford plea. That means you can plead guilty if you don't admit that you did anything wrong. But that doesn't guarantee you the right to go into my ILC program. So if you did this, ILC is a good resolution. If you didn't do this, ILC is a terrible resolution. Do you understand all of that?
Yes. Yes.
How old are you, Miss Santana?
74.
How far did you go in school?
High school.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No, I don't drink and I don't take no drugs.
Are you taking any medications?
Well, right now I'm taking for my how do you call that? Because I suffer from panic attacks and since my son passed away, I haven't been the same. I've been like
Let me ask it this way, Miss Santana. Are you taking anything that would interfere with your ability to understand what we're doing here today?
No.
Are you a United States citizen?
Yes, I was born in Brooklyn.
I have a form here. It's called titled Change of Plea and Entry. It's like on the second page, there's a signature. Is that your signature?
Yes.
Did you review this with Mr. Brenner before you signed it?
Yes.
Are you satisfied with the representation that you have received in the case?
Yes.
You're going to enter a plea of guilty to 1 count of receiving stolen property. This is a 4th-degree felony. 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. It also carries with it an optional period of post-release control of up to 2 years. There is a presumption that even if you don't successfully complete the ILC, and I'm not saying that you're going to, but if you don't complete the ILC, there's still a presumption that I would not send you to prison.
Okay.
Before we go any further, though, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it, and we're going to get on to the matter of the ILC. Is that what you want to do?
Yes. Yes.
Mr. Harris, did we have the opportunity to consult with the victim prior to today's hearing?
Yes, Your Honor.
And what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about June 23rd, 2025, Sally Santana received, retained, or disposed of a check issued to her ex-husband, which was altered and deposited in her name into a JP Morgan Chase bank account, which is located in the city of Mason, Warren County, Ohio.
Anything on those facts, Mr. Brenner?
Nothing on those facts, Your Honor.
Ms. Santana, did you hear those facts?
Yes, I heard it.
Do you admit that they are true?
Yes,
Do you understand the rights you're giving up by entering a plea?
yes,
Which plea?
guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan. You're doing outpatient at Butler Behavioral, is that right? We'll continue in that.
Yes.
I do think it makes sense for us to obtain maybe a more comprehensive assessment
Yeah.
to see if some medications are appropriate.
Yes.
And you're going to be under the general supervision of the probation department on my mental health docket. You're not on probation, but those are the folks that supervise my ILCs.
Yeah.
And you're going to be subject to random drug testing.
Okay.
We have $136.31 in restitution, which is owed to who?
It is JP Morgan Chase Bank.
All right, that's all. Good luck to you, Ms. Santana.
Okay.
Thank you, Your Honor.
Thank you.
Okay, so we're all set. Like I said,
Yeah.
you're gonna meet with probation
Yeah.
and then,
That's
follow
correct.
from
It's
there.
JP
If
Morgan
you have any
Chase
questions,
Bank.
give me a call, but otherwise,
I'll go
it's
back
in
to
Mason.
Jacob.
she's gonna bring you back right now.
Oh, okay.
And,
Can you come back with me?
well, I mean,
I'll
that's a
take
question
this
for
off.
them. I think you should.
That warrant will issue immediately. Thank you. Are they ready?
Yes.
Court recalls the cases of the people versus John Burdine and Carla Board.
Morning again, Your Honor, Raymond Cook.
John Burdine, who's approaching the court. John, state your name.
John Bordine?
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Bardine. Would you please state your name now? Carla Bardine.
Your Honor, we were attempting to reach out to the victim. The line that we had was not answering when we called him. I don't anticipate, excuse me. I do not anticipate being able to get proof of his hospitalization today.
Judge, we would ask these matters be dismissed.
Yes, Your Honor, we will. Motion.
This time, the people being unable to proceed, this case is dismissed. That's without prejudice on the defendant's motion. Folks, you understand that these cases could be reauthorized. You understand that? Okay. Thank you. Jesus. I think he gets an adjournment. Jesus gets an adjournment. If I asked for it. Okay, and there ain't been. Court does call the case of the people of the state of Michigan versus Jesus Hernandez Palestino.
Morning, Your Honor, Raymond Cook.
Assistant Public Defender Ben Dunaway on behalf of Mr. Jesus Hernandez Palestino, who stands to my right. Would you state your name for the record, sir? Jesus Hernandez, Your Honor.
Thank you.
Your Honor, this is the date and time set for preliminary examination. People are ready to proceed today by him asking for an adjournment. The reason for that being, based on my conversation with the victim who is present, I believe he would need an Arabic interpreter, and we did not secure one in advance of today's examination. Additionally, there is some additional investigation I think would be helpful to both parties that we've put on in the meantime that might help resolve this case.
Any objection?
Yes, Your Honor, the defense would ask for a dismissal. I think the second part of Mr. Cook's statement is really what we're interested in. And the fact of the matter is the police report doesn't allege the elements of the charged offense. So more investigation is in fact needed. It's unclear if more investigation would make this a case that the people would actually be able to proceed on. That might happen, it might not. But at this point, the defense would just ask to dismiss. They can refile it if their investigation turns something up.
Yeah, but I can't really do anything because they don't have an interpreter.
To dismiss it?
Well, they don't have an interpreter for the victim, the alleged victim in the case. Right? So even if they were wanting to go forth today, they can't.
Well, they couldn't, even if they had an Arabic interpreter here, they would be unable to proceed today, Your Honor. I'm serious. I could file a motion to quash the warrant. They didn't allege the elements of the charged offense.
You know what? Now everybody's gonna be trying to file that. You know what? Go ahead, file it, file their motion then. I'm not dismissing.
Okay.
I'll adjourn this matter to 24th.
Yeah.
I'll adjourn this matter to March 24th. Court
and I could-
finding good cause based upon the lack of an interpreter. 2025, 26, 9 AM before me. I'll continue.
Okay. Thank you, Judge.
You know what? Never mind. I have so much to say. I'm on the record. I can't say it.
That's right.
I can say what I want to say. Some of it's not real good, though, you know? Might not be judgely. What is Miss Sar's one?
Yes.
That's gonna go away.
Okay.
Maybe, I think he's talking.
Yeah.
So who?
So Mr. Lee has, his client is in custody of 2 cases. They are waivers. We're just waiting. Mr. Chabot in judge courtroom.
So Mr. Levo's cases are waivers.
Correct. Correct.
Hmm?
That is my understanding, yes.
She can cover well.
Then I will call.
Snyder. Snyder was not.
Get rid of child
Yeah,
abuse.
then he added a count to like, Yargo.
No, it wasn't. Hold on, what?
This may be a more involved waiver. We may need Mr. Chabalowski, so I will go get.
This may be, okay.
File that we haven't seen yet is Mr.
Johnson.
Yeah. Go ahead. He's gonna try and find someone to cover it.
He's what?
So he's gonna try and find someone to cover it. No. No.
So is that gonna change things?
No.
We're bringing him. Are you guys ready? Court does call the cases of the people versus Kirby Snyder. 2 cases.
Yeah, Chabalowski. Just explain why. That's right.
Listen to child abuse.
Judge.
Hang on, I need an appearance.
Assistant Public Defender Davi Lieb on behalf of Ms. Snyder stands to my right.
Your name, ma'am? Thank you. All right.
Your Honor, as the case.
I don't understand.
We received the lab report today. And I informed Mr. Levo of that. Are you moving to adding
He does not,
count two of
he does not
possession
reduce
of
anything right now.
cocaine,
He wants it all to be dealt with in circuit court.
the 4-year felony under MCL 333.285,
That's a good idea.
and I prepared the information to that.
And Your Honor, I have received the information, reviewed it with Ms. Snyder, and Ms. Snyder has executed an exam.
This is on 489.
Yes, Your Honor.
The amended information on one, yes.
All right, and so as to count 2, she's waiving the formal reading of that and standing mute to that charge.
Yes, Your Honor.
And ma'am, and the court will accept that standing mute to the charge and our not guilty plea as to count 2.
Okay,
And then you're waiving your right to a preliminary examination on that case, ma'am?
yes,
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yeah,
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
yes,
People also on that case waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2.
Your Honor, we acknowledge receipt of the information, waive formal reading, and stand mute as the circuit court arraignment.
Defendant having waived formal reading, standing mute, both counts court will enter a not guilty plea. Pretrial will be set for.
March 19th at 1:30 for Judge Slay.
I'm sorry, you said March 19th,
Yes, for Judge Slay.
2026. 1:30, Judge Slay. Bond on that matter will continue. Probably got to do this way. All right. Takes care of that.
Yes. Represented by Mr. Elter, we have Mr. View from the Prosecutor's Office, Officer Bridgman from Probation. We're here today, Mr. Bryant, because your attorney has filed a motion requesting something called intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge. And instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes outpatient treatment. You're going to follow the rules. You're going to refrain from the use of drugs or alcohol during the treatment period. If you do all of those things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I can revoke the intervention in lieu of conviction and proceed to sentence. One of the things that may be a sticking point in this case, Mr. Bryan, is when I say drugs, I include marijuana in that. So if you're on ILC and marijuana are fundamentally inconsistent with one another. I would probably have a different view if you were on probation, but if you want to go on ILC, you're going to stop using marijuana in all forms. I don't care if it's medical marijuana, something you bought from your cousin, I don't care what it is, you're going to stop that. Understand that?
Yes, sir.
How old are you?
They're 44.
How far did you go in school?
Graduated.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Just my regular medications, which the Shelby lady had a list of.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No.
Are you a United States citizen?
Yes, sir.
Other than what we talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Elter before you signed it?
Yes, I did.
Are you satisfied with the representation that you've received in the case?
Oh, yeah.
You're going to enter a plea of guilty to 1 count of theft, 1 count of misuse of credit cards. These are each 5th-degree felonies, punishable by up to 12 months in prison and a $2,500 fine. There are also the maximum sentence also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes, sir.
Mr. View, has the state had the opportunity to confer with the victim in the case?
Yes, Your Honor. The victim understands that ILC has been requested and that the court may grant it. They were primarily interested in restitution.
What are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that in the time period of April 7th to April the 25th of 2025 at locations within Warren County in the state of Ohio, the defendant did misuse for his personal use a credit card authorized only for uses related to his employment by the village of Mainville, the value of which was greater than $1,000.
Anything on those facts, Mr. Elton?
No, Your Honor.
Mr. Bryant, did you hear those facts?
Yes, sir.
Do you admit they are true?
Huh?
Do you admit that
Yes,
they
sir.
are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction, and we're going to order these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan for outpatient treatment. I understand you're already engaged in treatment through Talbot, right?
I was, but kind of stopped.
Okay. The treatment plan is going to include random drug testing. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. So we have two issues that we have to address, Ms. Bryant. First of those is the restitution. How long is it going to take you to pay this $1,400 some odd dollars?
3 or 4 months.
Okay, so let's call it 3 months. So we're going to have, let's call it by, let's see, what does that take us, May 24th? I want it paid by then, or I want a violation. How long is it going to take you to get clean urine test?
Next couple of days, it's been like 32 days.
All right, so let's call that 30 days. So we'll have a clean urine screen in the next 30 days. Anything else regarding the treatment plan?
No.
All right. Yeah, Ms. Bryant, you got to stop the marijuana, pay back the restitution. Hopefully you and I won't see each other anymore.
You ain't gonna see me no more.
All right, good luck to you.
Thanks, Your Honor. Thanks, man.
Hold on a second. Why do I have this? Is it she waiving on the other file?
Yes, Your Honor.
Okay, I did that. On the other case, you understand that you're waiving your right to a preliminary examination.
Yes.
All right. Preliminary examination in that case also having a defendant is bound over to circuit court on both counts. In that case, defendant, you're waiving reading of that.
Yes, Your Honor.
Standing in.
Yes, Your Honor.
Court will enter not guilty plea. Pretrial will be set March 19th. March 19, 2026, 1:30, Judge Slay.
Thank you, Your Honor.
We'll continue.
Thank you.
Thank you.
Sign information.
Very good. Ready on Sarah?
Yes.
Court does call the case People versus Mary Sarah.
Okay, well,
Good morning, again, Your Honor. Dan Garrett on behalf of Ms. Sarr, stepping forward.
Hello, sir.
Your Honor, at this time, one of the witnesses that I believe we will need to ultimately proceed with this case is unavailable, and therefore we are unable to move forward to the next.
We have a motion to dismiss, Your Honor.
People being unable to proceed this time. Case is dismissed on motion of defendant. Ma'am, you understand that's without prejudice, meaning that the case can be brought back.
I understand.
All right, very good. Thank you.
Thank you, Your Honor.
Johnson. Mr. Johnson did not get money.
Is it anticipated to be like a waiver or something, or
It's a remand, Your Honor.
it's a remand? All right. Are you in communication with him at all?
I was up until a little bit ago. He said he doesn't know him a big here. He was asking if he could do it off the record, which I don't like.
I'm now. If, let him know if he has an opportunity to zoom in. I'll, come back out and I'll handle it. Okay, because that's all I got.
Did the court call White? I'm sorry. Go White?
Yes, we
Thank you.
did. There was a bench warrant.
Thank you.
All right, so I'm gonna step off and then if we can get Mr. Johnson via Zoom, then I'll come back on and we'll deal with it. What's in recess? Oh, right. Day. Let's go.
Good morning, Mayor. Please, Honorable Court, Kareem Johnson, on behalf of Mr. Watkins.
Marcus Watkins here. All right, very good.
And Your Honor, today is the date time set for preliminary examination. At this time, if you are unable to proceed as to count one, would ask for count two to be remanded down to the district court.
You move to dismiss on count one, Mr. Johnson.
Yes, Your Honor.
All right. I'll continue to defendant's not guilty plea to the count two domestic violence. I'll set that for pretrial on
March 12th at 9 a.m.
March 12th, 2026, 9 a.m. before Judge Barr.
Your Honor, will the court consider removing the tether now that the felony has been dismissed?
Your Honor, at this point, I would object to that. I think it's something that can be addressed before Judge Barr.
All right. I'm going to decline at this time to change any conditions of his bond. He'll be before the Judge Barr very soon, and they can monitor that better. All right. So I'm going to decline that. His bond will continue with its conditions. All right. Thank you. Thank you, Mr. Walker.
Your Honor, and the government, Mr. Watkins, I apologize. Thought we were going to finish this trial late last night. We did not.
Oh, you thought you were going to finish. I got you. We knew something had happened, and so we got it taken care of though. All right. Thank you.
But I apologize, Your Honor.
All right. Thank you for jumping on Zoom so we can get it taken care of. Take care. Have a good day. That's it for us. Court stands in recess, I think, because I may be taking some from Judge Barr. I'm not
Mr. Porter, is that true? Is that your understanding? So you're agreeing to pay Mr. Whitby, actually DBC America LLC, that should be to whom the check is made payable. You're agreeing to pay them $1,800 with the understanding that you'll pay $300 per month commencing on March 20 and the 20th of every month thereafter until paid in full. True? All right, here's what I have to do. I'm going to fill this out. I'm going to fill this out for you guys. I want you both to read it. And you're going to have to sign it if it's going to be a consent. So I will write everything out. And I'm setting forth everything you just told me, $1,800 installments, $300 monthly starting March the 20th of 26. On the back here, there's a place for you both to sign. For some reason, they have defendant's signature at the top. You'll see where the X's are. Take a good look at this judgment. If it meets with your approval, sign it. and then give it to my court officer. I'll recall this and we'll be out of here in a couple of minutes, okay? Thank you. All right, is absolute resolutions versus Tiffany Holly here. Tiffany Holly, you have to start your video. Mr. Burke, your name?
Thank you, Your Honor. Hal Burke, P69068, attorney for the plaintiff in this case.
Ms. Holly, your name?
Tiffany Holly.
Good morning to you both. Any resolution on this?
Yes, Your Honor, this case is resolved. Ms. Holly has actually already begun her payments. She will be paid in full by March 27th. With
Is
your
this a
permission,
conditional dismissal or a consent?
it's going to be probably just a dismissal with prejudice. Would you be willing to continue it beyond that March 27th date? And if I know she's going to, she mentioned she will make that final payment by the 27th. I will just dismiss the case with prejudice. When she makes that, it will be the third and final payment.
Well, what are you asking me to do? You want me just to adjourn the pretrial?
Yes, would you, if you would be willing to do it, maybe that
Adjourn the-
first week of April, I think you'll have the dismissal with prejudice before then.
You're gonna have to submit a stipend order then, okay?
Sure.
To dismiss with prejudice. I'll adjourn this to, give me the first weekend. that I'm
7th.
here. April 7th. At 8:30?
8:30 would be fine. Yep.
Yeah, so you submit a stipend order to dismiss with prejudice, assuming she's made her payments. I'll be glad to sign it. Otherwise, you guys have to be on April 7th at 8:30, okay?
Thank you, Your Honor.
Thank you. Have a good day. And you agreed to all those terms, right, Ms. Holly?
Yes.
All right. Good luck to you, ma'am. Thanks. Thanks, Mr. Burke. DBC America versus William Wayne Porter, 2504786. Gentlemen, your names?
Matthew Whitby.
Mr. Porter,
William Porter.
did you sign, read, and understand this proposed judgment entitled consent?
Yes, sir. Yes,
And you did too as well, Mr. Porter?
yes, sir.
All right. And this was how the terms were laid out to me, correct, Mr. Whitby?
Yes, sir.
Correct, Mr. Porter? I'll go ahead and sign it. You guys can both go down the hall. They will give you a copy of the judgment and you'll be out of here in a couple of minutes. Have a good day. Congratulations on settling that. City of Dearborn versus Irvin LeBlanc.
Christina Codrington, P number
Oh, wait, I got it. I'm sorry. 2505282. I'm sorry. Your appearance? Ms. Codrington, your name, I'm sorry.
Christina Codrington, P number 88961 for the plaintiff.
Is Mr. LeBlanc, and I said Kevin, it's Irvin LeBlanc is the defendant. Your name?
Yes, sir. Irvin LeBlanc.
Any resolution on this, Ms.
Not at
Codrington?
this moment.
All right, I'm gonna go ahead. I'm gonna set some dates. What's this about?
This is an unpaid medical bill. Defendant believes should be paid by workers' comp. And that is why an agreement could not be reached.
Did you work for the city of Dearborn?
No, sir. I was working in the city of Dearborn on a Ford project.
Well, why? So you think Ford should be paying it?
The workman's comp company, I notified the Velo, the company that is trying to collect the money, the unpaid bill, and I CC'd that company. They're just waiting on a bill from Velo or the city of Dearborn. They're willing to pay it. They just need the bill.
Are you gonna send it to him, Ms. Codrington?
Send the bill.
The ambulance bill, yeah. I contacted your company or the company you're
Let me just tell you something, Mr. LeBlanc.
Yes, sir.
That's between you and Ford Motor Company. Ms. Codrington doesn't have to act as the go-between. And your ambulance bill, whether you were hurt in the city of Dearborn or not, with all due respect, and I hope you weren't hurt badly, that's not covered by workers' comp. in terms of City of Dearborn's ability to collect it against you. So, I mean, I could just set this for trial and we can be done with it, but you're gonna owe this debt. Whether you get reimbursement or not is not the subject of this litigation. They can't be hamstrung by the fact that you're trying to get money out of Ford or Velo or whoever else. You understand what I'm telling you?
I do understand, sir. When I disputed the claim with the company, I was
What
just
company? The ambulance company?
not the ambulance company, sir. I got the notification from the collection agency or the law firm who is representing them, which I believe is a Velo collections law firm or something like that. And I notified them when I disputed it that they can get whatever information from the.
Wait a minute,
Missouri-
let me explain something to you. If I go to a doctor's, somebody goes to a doctor's office and they have insurance and Blue Cross isn't paying the bill, you've still signed, you're still obligated to pay the bill directly to the doctor. And you can then go after Blue Cross or whoever your insurance carrier is. This is not their issue. They don't have to act as the go-between. So really, I mean, based on what you're telling me, I don't even know why we're going on this case. You should pay the bill and go after the other company if you think it's covered by workers' comp. But they don't have to collect it for you. This is their claim against you.
Yeah, I guess this is just my ignorance in the situation, sir. I did not think it would be that I just assumed that the company that would have the bill that they could just send over as far as like a copy of it. Because
Why don't you send it over? Why do they have to do your work for you?
It's 2 years ago. I didn't still have. I had already sent the bill over to them a long time ago, and I couldn't find the information again. So I didn't know. I'll contact the city of Dearborn and try to get the bill and then send it over. And I mean, we can go to trial. And like, I understand that I am liable for the bill. That wasn't.
Well, that's what I
Somebody has
mean.
to
Maybe
pay.
your better option is to get on the phone with Ms. Codrington and say, hey, let me pay you, and then I'll go after them. It's not their responsibility. I'm simply setting this for trial for March the 18th. I'm sorry, May the 18th at 8:30, 10:30, March the 18th at 10:30. You don't need any discovery, do you, Ms. Codrington?
We would just ask for the standards. No, I don't think, probably we won't, since we have everything here.
Okay, so unless you want some documents or discovery, Mr. LeBlanc, I'm not gonna order that. But if you tell me, Judge, they've got documents or that I need, or I want to send out interrogatories, then I'll be glad to give you the discovery.
Can I ask it for the discovery of the bill? For the initial ambulance bill?
Yeah, you're gonna send them that bill, right, Ms. Codrington?
Yes, I can send him that bill.
Do you need anything else?
Me? No.
Okay, so then I'm just gonna set it for trial, Jennifer, May the 18th at 10:30. But I hope you're listening to what I'm telling you. You seem like an intelligent man. The issue only that I'm gonna address is whether or not you owe the money to the city of Dearborn. Okay?
Okay, thank you, sir.
I wish you both well. Good luck. Thank you.
Thank you.
Thank you.
Brooke Gorham versus Eastern Account Systems of Connecticut, Inc., 2504915. Are they here?
No, Your Honor, I've not had them check in.
Do I have proper service here?
We have, I believe it was certified mail signature at a resident agent address. I believe it should be printed.
What's your name, ma'am?
Brooke Gorham.
What is this for?
It's for a collection account.
Tell me.
It's being double reported on Equifax.
Hang on.
And-
Be more specific.
They basically split one collection in two. And are reporting two instead of one on Equifax. And the balance is fluctuating every week.
Hang on a second. So this is over them claiming that you owe money. Are you telling me that you don't owe?
I do owe one collection, not two.
And how much is the one collection that you owe?
The statement they gave me was $572.
Well, how are you suing them for $7,000?
Because they're double reporting on my, credit report.
How are you damaged to the tune of $7,000?
I wasn't able to get financing that I needed.
And you're gonna have to be more specific on this. Financing for what?
Dental work.
I need more than that.
Okay.
I don't know what, who told you to do this? Lawyer?
No, I had filed so many disputes with them trying to fix it. I just could not.
Well, yeah, but you can't just come up with a sum of money out of the air and allege it and claim that and this assume that or think that the court's going to give you this. You have to still somehow show that you've been damaged. Jennifer, I'm gonna do this.
Yes, Judge.
You want to get their attention anyway. I'm gonna enter a default. Defendant failed to appear. Enter default. Schedule hearing on damage issue, okay? We're gonna set a hearing on damages. You're gonna have to provide me them. I'm sure there's statutes out there that prohibit them from doing this. But you're gonna have to find them. I'm not doing your work for you, okay? And I'll give you a date about 5 weeks out. And you can prepare plaintiff to prepare documentation justifying amount claimed. So just to come in and say, I didn't get financing, I don't know what your damages are, but you can find statutes, you can prepare that document due by why don't we do by March 13th? I'll make it March 16th. We'll set this for early April,
April 7th, Your Honor, at 10.
April 7th at 10, okay?
That's perfect.
Well, prepare a default, if you would, Jennifer.
Yes.
We'll send that out to them, okay?
Thank you, Your Honor.
Thank you very much.
Another one on top right.
Yeah, another, sorry.
What's this one?
It's TransUnion.
TransUnion, and they do have someone here on Zoom.
Oh, boy. What are you doing this for a living or something?
I'm just trying to get all the bad stuff off my heart. I've tried to these people.
All right, where do I have Swindle and Linville? Virginia Ann Swindle versus Tracy Lynn Linville. 2402676. I cannot believe we're still going on with this. What is going on? How much have you paid this judgment in full, Ms. Linville? Your name?
Tracy Linville?
Your name?
Virginia.
Have you paid this judgment in full?
I was paying every single week. I got attacked by a husky and broke my hand. I couldn't work. I sent her a letter that day. And I sent her several letters.
Well, this is up for a creditor's exam today. You realize that?
I could have continued paying her within 6 weeks. Because you told me that to deal with her, that she is in charge now.
Well, I didn't say she was in charge. I wouldn't use that word.
Well, you said you want to see it back in here.
Well, I didn't say that. I didn't appoint her judge. You're not suggesting that, are you?
No,
Okay,
I sent her several letters.
ma'am, listen.
I was able to.
Ma'am, listen. She has the right to conduct the creditor's exam today. Okay? You received the subpoena. See this? Subpoena? Order to produce, order to appear and or produce.
I've been waiting for you for this, because I wanted to pay her. I told her within 6 weeks, I was back to work, I could pay her.
No, but you, when was the judgment entered? December.
Judge,
Go
I
ahead.
was gonna say, Judge, if I may, there was a order for installment payments entered in June of
Right.
last year. And then in October, Ms. Swindle filed a motion to set aside. In October 23rd, there was an order setting aside the payments.
You're here for a creditor's exam. Did you bring everything you were supposed to in the subpoena?
I brought all of my documentation.
Okay. Here's what I'm gonna do. Ms. Swindle, you're gonna get to go in a room and ask her questions. Do you understand that?
Yes.
I'm gonna ask you to raise your right hand, Ms. Linville. You don't have to raise your right hand, Ms. Swindle. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole true self you got.
Yes.
All right. You guys go in a conference room. You can ask her all the questions you want. You can look at all those documents. And then you guys can come out here and tell me that everything did or didn't go well. Okay? That's what I'm gonna have you do. My court officer will show you a conference room. Thank you. Velasquez. 25B149563. All right, your name?
Gustavo Velasquez. The Baldwin Extension son.
Hang on a second. What if I do? Find you $200? How much does he owe now? How much do you owe now?
The same, I believe.
How come you're taking?
I've been unemployed. Well, I got on unemployment. One lawsuit, I had injured my shoulder in October, but I'm going back to work in March. I'll be able to take care of it.
When are you gonna pay this?
Before, for sure, before the 15th of next month.
I'll give you until the 15th of March. Okay? If you need more time, you come in here and talk to me. Don't ignore me, okay? You pay in full by March the 15th. I don't know how exactly, you might want to go down the hall and double check as to how much you owe. Okay? Dillard, you're all set. Derek Kendall Dillard, 05B7535H, B, C, and A. You gotta be kidding me. Please tell me you're kidding me.
No, Jack.
Please tell me you're kidding me. Are you Mr. Dillard?
Yes.
You appear on Zoom. You haven't taken care of these tickets in 21 years. Are you kidding me? I don't care if you live in Tuscaloosa, Alabama. What is going on here?
Judge, Mr. Dillard moved from that address shortly after he got the citations. He did make some payments against those civil infractions, Judge. But he's lost contact with the court since. When he was told that his warrant was pending, he did contact the court. He was actually here last Friday on Zoom. And then he had, I believe, some technical issues and he ended up falling off, so he came back on today. But I believe he did make some payments towards the civil infractions.
Forgive me, but I want to laugh. Only I'm not amused. So I want to get this straight.
Yes.
He has citations from 2005, the misdemeanor of which was never taken care of.
Correct.
And he gets on and he calls the court and he says, I want to take care of this now. And he wants to do it from Dayton. Is that where you live now, Dayton?
Yes, sir. I did update his address.
Does he have all the money to pay?
Judge,
He's not going to ask me for a payment plan, right?
well, we're just looking to see why the amounts were so high. He posted 195 against one ticket. There was a balance due of 128. And on the other ticket, I believe.
Because when they blow off defaults and show causes and everything else, or blow off court and go into default, can you pull those up?
Just for the misdemeanor rule stand, you would.
I don't even know if I want to do this on Zoom. Can you pull him up?
Yeah.
You gotta be kidding me. What have you been doing for the last 21 years? You were, let's see, you were the whopping old age of 38. When you got, no, yeah, 38 when you got this citation. And now you're gonna be 60.
Yes.
Which one do you want to see?
He owes 114 on the limited access. He owes 128 on the no proof of insurance.
Yes,
Can he pay those now?
would the court consider, and I understand your position, Judge.
You don't dare ask me to set aside this.
Not to set aside, but would the court be able to waive any late fees or just make?
I'm not gonna negotiate with a guy who hasn't been here since the early 21st century. Are you kidding me? I'm not doing anything. You're gonna have to appear here, okay? You deserve to drive from Dayton, Ohio. You deserve to have to drive here from Spain, as far as I'm concerned, when you don't show up for 21 years. I'm not taking care of this for you. I'll cancel the warrant. We'll give you a court date. Have somebody come on. Wait, let me see. I'm setting this. Can you be here tomorrow?
No, Your Honor.
I'll give you till March the 19th to appear at 10:30 in person. I'd bring some money with me. I'm not even arraigning him now.
What is the total amount of the justice? 40?
Well, he's got 118 or 114 plus 128 is 242. He owes a clearance fee on the suspended license. That's 287. And he has to adjudicate the suspend charge.
They need to make the 287. When he comes in.
I'd come in with a lot more than that. He's gonna take care of the suspend charge when I was young that ticket was issued.
Judge, he just started his job as a janitor at, he's only been there for a week. And he makes roughly about $500.
I get it. That's too bad. I don't know what to tell him. I'd have been a lot more understanding if he'd have shown up here in 2005. So I'm canceling your warrant on this one case. We canceled on the civil infractions. And I'm not cutting these fines down, if that's what you're asking me.
No, yeah. I'm not-
He owes 114 and 128. That's $242. Can you pay that today?
No, sir.
You're gonna have to show up in person. Okay, that's it. That's the date. We will send it out, but you should write it down. The date is March the 19th at 10:30. We'll see you here then. You don't show up, this will be in effect until I'm gone. Good luck. Thank you. All right. Brooke Gorham versus TransUnion LLC, 2504914. Ms. Gorham,
Yes, sir.
I'm having a hard time understanding all this. TransUnion, I need you here.
Good morning, Judge, you're frozen, just so you know.
I am good. I look
Yes.
better when frozen.
Well, just if you can't see us, that might be why.
All right. Good morning, counsel. Your appearance?
Good morning. I'm sorry, I'm not counsel. I'm corporate representative for TransUnion.
I'm sorry. Danielle Nolan?
Yes.
Do you want to go into a breakout room and try to talk this through with Ms. Gorham? She's suing you for $7,000. Are you screwing up her credit report?
No, Your Honor. We can discuss it. That's fine.
Breakout room and talk to her?
Sure.
All right. We'll put you in a breakout room. I'll let her talk to you.
Thank
And
you.
then if it's not resolved, I will come out, okay?
Thank you.
Either way, I'm coming out. So you guys let me know if you reach an impasse. Thank you.
Sure. Probably.
Well, first of all, let me call Swindle and Linville. Recalling Virginia and Swindle versus Tracy Glenn Linville, 2402676. All right, Ms. Swindle, your name? Ms. Linville,
Tracy Glenn.
did everything go okay in there? Did you get to ask her questions? Did she answer your questions?
Yes, she said she didn't have the information she was supposed to have.
Why didn't she have it? You gotta go get it.
She didn't ask what she wanted to know about the accident. She asked me where questions.
Wait a minute. Where's your job address? Where do you work?
I don't have the job address. I told her I was there 150 a week.
Ma'am, she gets the garnish wages.
I'm gonna go here. This is bad.
Nobody's.
game.
You don't get to refuse to answer questions. You don't get to refuse to answer questions.
I don't.
Ma'am. Let me just reiterate. You don't have the opportunity to refuse to answer questions here. This is a subpoena. Where do you work?
At Novellas in Woodhaven.
So,
Novellis.
and what is the address? Go find it. Go find it. I'm telling you, go get the address and come on back in here. You got a subpoena. And I'm not gonna don't roll your eyes at me, Ms. Linville, Ms. Linville. Miss Linville, I said your name. Come back here. You don't get to go out of here and sit down. Right there, sit. You don't get to go out of here rolling your eyes, disagreeing with this judge's decision, announcing that you're not a criminal, and then storming out of here and pulling doors open where they're hitting the pews. You got it?
Sorry. I'm very sorry. She worked me out very bad.
You don't get to do that. I'm telling you, go get all this information.
Yeah.
Go get it and come on back in.
Well,
Yeah, quietly, nicely, not in a tiff. Gorham versus TransUnion LLC, 2504914. All right, any resolution on this? Ma'am, your name again.
Danielle Nolan,
And what is your position with TransUnion LLC?
corporate representative.
And your name? Any resolution on this?
Yes, Your Honor.
What is it?
We came to a resolution of she's going to delete the Eastern account that's inaccurately reporting and write up a settlement agreement.
Correct, Your Honor.
You guys just want me to adjourn this?
It's up to the plaintiff. I'm going to send her over a settlement agreement by the end of the day. So I would
Okay,
prefer her
I'll
to
just-
dismiss
here's
it.
what I'll do.
Okay.
Adjourn case.
Mhm.
Defendant will delete. What is that again? Eastern account, we've said, what is it?
Eastern Account Systems.
Eastern account systems. From credit report. Parties will enter into settlement agreement. I'll adjourn this 2 weeks. You said you're going to get it to her today, correct?
Yes.
We're gonna adjourn the small claims hearing for 2 weeks, Jen, if you can give me a date.
Judge, I don't really have anything in 2 weeks.
Well, 3 weeks, 3 weeks.
Okay, I can do the 24th. If that, I know that's a little more, but
You guys are gonna get that paperwork into me, right? Today or in the next 2 days?
Yes. Am I going to email it to you? Can I email the court or I can mail it to,
Yeah.
okay,
All right, the civil clerk will go in and chat with you, okay?
okay, no
All
problem.
right, thank you. I'll adjourn it until that date, okay? So hopefully you won't even have to come back. Delete that from a report and then send it in March 24th at 8:30. Wish you well.
Judge,
Thank you,
can we
Your
do, Judge, can we do 10:30 on the 24th?
Yeah, that's fine.
Okay.
At
And then-
10:30.
Yeah,
Okay,
and Miss Nolan, I'm gonna
Thank
take you
you.
into a room.
it's all right. Did you find the address, Ms.?
Yes.
Then why are you telling me? Virginia Ann Swindle versus Tracy Lynn Linville, 2402676. Your name?
Tracy,
Do you have your bank accounts?
no.
Go get them. Go get them. She didn't subpoena them. But she can do this again. Just pay her the money. How much does she owe you, Miss Swindle?
Want to. I'll still owe 2,000.
Well, you're not doing a very good job. How much was the judgment for?
3,000.
3,136. Yeah, say something.
You guys are making this hard. I've seen you guys more on this little case. I can't even tell you how many times. I want you to pay her. I want you to pay her. Well, you didn't pay October, November, December, January, right?
Fortunately, I had to wait for this to come through. I came in here twice.
Do you have an installment payment order down there again?
Every week from when you started it until I hand her over.
Yeah. Jennifer's not down. Are you down there, Jennifer?
Yes, Judge, I just got out of the
I
breakout
need you to
room.
prepare an installment payment order. How often you get paid?
Every week.
Every Friday?
Yes.
How much can you pay every week?
I was paying $100 every week.
Let's put it down for $100 a week again. Next
Okay,
time you'll
it'll
be able
take
to.
me a couple minutes to type the order, Judge.
Yeah, and then my courthouse will get it. You both can look at it if you agree to it. This is easier for both of you, but you got to stay on your payment schedule. Otherwise, I'm setting aside the installment payment order and she's gonna be able to garnish your wages. Is that okay with you, Ms. Swindle?
Yes.
All right, she's gonna prepare the proposed order. You two are gonna look at it. I'm going on to another case. And we'll go from there, okay? Thank you both. Jeez. Concord Consumer Housing versus Mount, 2501975.
Judge, I have them in a breakout room right now. Unless they're back,
Okay.
I can't, I'm not at my computer, so I can't see.
Likelihood of them settling this. But I agree, that's fine. I thought they were gonna settle it last.
Yeah, they
week.
request, Mr. Gallup requested to speak, so.
Okay.
You guys are all set.
Jen, no, you gotta come back in here though, after you read the order. She's preparing it. You gotta go get the proposed order. here's what I want to do. Would you ask the prosecutor on your way down to get that proposed order? Whoever handled that SEAC case, I don't remember who did it. Was it Ms. Holloway? At the preliminary exam?
Yes.
Ask Ms. Holloway if that is going to go. It's at 1 o'clock,
Okay,
The trial.
the trial.
okay.
Okay, Jennifer, I'll be in my chambers if you can let me know.
I will, Judge.
You. I'm going to consider this an oral motion. You want to pay weekly installment payments, correct?
Yes.
And you get paid every Friday. Can you start this next Monday? That would be March the 2nd. There's no, Jennifer, there was never a garnishment issue here, right? I don't have to worry about
Correct. There
that.
hadn't been one yet. No.
I'm gonna go ahead and order. I don't need you guys to sign this. You pay $100 starting on March the 2nd. So I'm gonna indicate you filed an oral motion with this court on February the 24th or 26th. You have to pay this judgment every week starting March 2 of 26. You can each go down the hall. They'll give you a copy of the judgment for your records. make sure you stay with that. If she doesn't stay with that, Ms. Swindle, you can file a motion to set aside the installment payment order. And then I'm gonna let you garnish wages, okay? We understand one another? We understand one another? Good enough. All right, have a good day. Thank you. It's John. You guys go down the hall and they're gonna give you a copy of that order. Mr. Gates, you don't have anything for me, do you?
Judge, I think he's just on Zoom from when he had that gentleman in Ohio.
So all I have now is,
Concord versus Mount, and they're still in the breakout room.
okay. Well. All right, I'm ready to go when they come back. Thanks.
Ellen was placed on probation in September of 2023. So she's been on probation.
So. You know anything about, what's his prior conviction for?
He has a prior
Because that keeps him
conviction.
from getting probation from a jury.
Well, he has a prior conviction for burglary of a habitation in 2004. He was
Okay.
sentenced to 9 years.
That's what, so then he picks up the unlawful possession by a felon.
Mhm.
So we know he's got a prior conviction.
Mhm.
This is- When was when did he get the regular probation?
Looks like it was 9/18/2023.
That's correct. Yes.
Okay. That's after he commits this.
Yes.
Do you know how many other convictions he has? Do you have any other convictions? Okay, so that one, so the state jail felony isn't enhanceable, just with one.
Mhm.
All right, so you're looking at up to 2 years in the state jail. But you're not eligible for probation because of your priors. So what do we do to?
I was just gonna put it on the announcements, assistant superior judge, and I'm trying to see if we can work it out. But I do have offers on the case and I do have the discovery on the case. And I also got the media on the case as well, so.
What don't you have? You got everything?
I think I got everything.
You got your wallet there too?
I got the wallet.
That's in there, okay. Well, that's everything. That's everything somebody needs. I'm gonna reset it, for announcement, okay? And we're not gonna go long, though.
No, that's fine.
I'm gonna give y'all 4 weeks to try to figure this out. And, Mr. Carrier, you're gonna get a resetting, just have a seat over there before you leave, okay? And Don, on gun. We're going to call out again just to see if she's here. John Kanita Brown, 24 CR 691, no answer here in the courtroom. Yeah, hey. Hey, you need a pair of socks or any of this?
I think I'm safe.
Yeah, you think so? Okay.
I hope so.
Glad to see. I was gonna worry if you were gonna pull out a bar of soap and start showering.
Well, you got to sink back there.
That was all.
Get ready back there.
All right. John Kanita Brown here in 24 CR 691, charged with a 3rd-degree felony of theft. There is no answer in the courtroom and no answer to the name being called into the hall. The defendant has failed to appear. A warrant shall be issued for her arrest and her bond, which was set at a number.
$20,000.
$20,000. It is doubled. Well, there's a big loss here. It is doubled to $40,000, plus she must have a GPS device as a condition of bond. A warrant shall be issued for her. Javion Johnson.
He's here.
Javion Johnson, 25 CR 1773. And you're charged with the 2nd-degree felony of aggravated assault, causing serious bodily injury, which carries with it up to 20 years in prison. And first thing we want to make sure you have a GPS device.
Yes, sir.
Where is it? Let me see it. It's on your ankle, isn't it?
Ankle.
Okay, yeah. Oh, well, it's GPS. It shows where he is at all times. Okay, so what do you do in the shower? Do you put a bag around it or something? No, okay. All right, well, they would have told you if it wasn't waterproof, not to get in there and do that. I mean, it's electronic, you don't want it to not work. You don't want it to electrocute you either. What are we doing today?
We're gonna ask for 4 weeks for his, he's got family members here, they're gonna be looking for some money.
Okay.
There's a video here.
There.
Have you seen that? You've seen the video?
Yes.
Oh, it has audio to it too.
Yes.
Put it on the trial document?
No, sir, 4 weeks.
Okay. Ashley, get it. Your attorney with the 2nd-degree felony of aggravated assault. And the person is still alive, huh?
Yes, sir.
It could have been a murder. What are we doing today, Don?
We're asking for 4 weeks as well. Her mother's here and they've asked me they're gonna be getting some. She's also currently receiving cancer treatments here.
Who is?
That's right.
Well, it doesn't stop you from getting indicted.
No.
You gotta follow the law.
4 weeks should be talking.
Anything from state? No.
No, you don't.
Okay, you got 4 weeks. Okay, thank you. That is all. Next is, Don, there was Megan Presswood. And I've got a note. Reset in jail, out of state.
She's in jail in Louisiana in the state.
What do we want to do today?
I think she's been reset it a couple of months. I don't know that we're gonna get her back. But
Yeah, she's jail in Louisiana, Judge.
For
Same
I
thing.
have no idea.
voting prostitution.
Same type of case. And I think she's gonna be there while they're not.
As soon as we get her back, we will.
Stephen Salgado.
He's here, and it's a plea, so I very good with.
And finally, what are we gonna do on Christopher
I
Salinas?
called the name, no answer.
Christopher Salinas, we'll jump ahead. 23 CR 1792, Christopher David Salinas. No answer in the courtroom. I ask the bailiff to call into the hall, please, for Christopher David Salinas. Let's John go over the pad.
You already did the discovery certificate.
Yes. You got a kid, please?
Thank you.
Three?
I'm working on it right now.
I don't even have you on the docket, but I'm great.
Yes,
It's a trial, it's a carryover trial, I'm just gonna straighten out.
Oh, okay.
No response, Your Honor.
All right. On 23 CR 1792, Christopher David Salinas. There is no answer here in the courtroom. No answer to the name called into the hall by the bailiff. The defendant has failed to appear. A warrant shall be issued for his arrest, and
$4,000.
his bond is $4,000. It is double to $8,000. Plus, the defendant must have a GPS device so we know where he is when he's not in court when he's supposed to be. Here. Stephen Salgado. Is that him?
Yes, sir. He does not, he speaks only Spanish, but this is his sister with Google Interpret.
All right. Mr. Salgado?
Yes.
All right. And what is your name, ma'am?
Graciela Hicks.
Okay. Great. Well, that was it. I asked your name, you said your name, and then there was a musical introduction. Yeah. So. And what do you do for a living, ma'am? What's your occupation?
Member services for Synergy Credit Union.
Okay.
Yes,
And how long have you worked there?
5 years.
5 years. All right. Do you know the defendant, Mr. Salgado?
Yes,
How do you know him?
my brother.
He's your brother. All right. And he does not speak fluent English.
No, he doesn't.
All right. You, on the other hand, are communicating
Yes.
fluently in English. Are you also fluent in Spanish?
Yes, sir.
All right. Have you spoken Spanish and English essentially your whole life?
Yes, sir.
Oh, I'm not going to ask your age, but you are an adult.
Mhm.
Have you had the occasion to translate before in
Yes.
proceedings?
Not proceedings.
Well, I mean, in functions.
Yes, sir.
For what, like, for example, what? What?
For work related,
Okay,
that's what I'm hired for by the.
okay, primarily work related.
Mhm.
Okay.
Yes, sir.
All right. Here, there's more of a formality involved
Right.
because there's an oath that's taken.
Right.
Because everybody takes oaths
Right.
when they're about to conduct business here. And the importance is to ensure that when we're doing translating, that the translation is done directly from the statements. You know, it's not, sometimes I'll hear a defendant who speaks foreign language speak, and it'll be 10 seconds in an answer, and then the translator will go, he said yes, and I go, no, there's no way that can happen. I know that didn't happen. So the translation must be verbatim.
Right.
And I'm sure that's the way you probably conduct your business as well. So we're going to, first of all, swear you in and raise your right hand. Do you notice that little memento?
That's good.
Yeah. In 1 minute, we'll swear him in. Do you, and your full name is,
Graciela Hicks.
okay. Oh, you're gonna have to, you
G-R-A.
roll right off your tongue so quickly.
Graciela. Hicks.
Really?
Mhm.
I mean, that's like, thank you.
Graciela.
I mean, is it?
Yeah,
Is that
everybody
what-
calls me Grace. Easier.
Grace? Oh, okay.
Yes. Mhm.
Then raise your hand. Do you solemnly swear that you will truly and correctly translate from Spanish, the language that your brother, Stephen Salgado, speaks, into English for the court reporter and all of us to understand? And you will translate the English statements that we make to the defendant, your brother, into Spanish, and you will do that truly and correctly, so help you God.
Yes, sir.
Lawyer. And so when we do this, it's kind of, you may do it this way, but it is, you're going to translate directly exactly what he says. So if I ask him, what is your name? And he'll say Stephen Salgado. If you say, he said Stephen Salgado, that would be wrong. You would just be speaking like you're speaking exactly what he's saying. Okay, perfecto. Let's just go. We just got this. You are Stephen Salgado.
Tú eres Steven Salgado.
Yeah.
He said yes, yes. He said yes.
God bless you. He answered in English.
Yeah.
But I know he knows a little bit.
A little
of
bit.
English. Mr. Salgado, do you understand that you are charged with a third-degree felony?
Steven Salgado, tú entiendes que tú eres agravado por una felonía.
And this is driving a motor vehicle while intoxicated.
Manejando un carro, un vehículo intoxicado. Yes.
It also states you have 2 prior DWI convictions, operating motor vehicles while intoxicated.
Que tú tienes 2 anteriormente manejando intoxicadamente. I think so.
Well, this is very serious and important.
Yes, sir. Es bien importante, esto es bien serio y bien importante.
Each time you commit a DWI or driving while intoxicated from here on, it's a felony offense.
Es importante porque cada vez que tú manejas intoxicadamente un carro, es una felonía, no es una felonía. I haven't been doing it now.
Nonetheless, if you commit another DWI, it's a third-degree felony like this is, which carries with it up to 10 years in prison.
No importa porque si tú cometes otro de nuevo, es otra felonía y es tercer grado de nuevo. Y puedes ir 10 años a veces.
Do you understand?
Entiendo.
Right. Is he entering a plea today?
Yes.
Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, Mr. Salgado.
You need to sample.
You didn't even know.
Yes, one's coming, but we're gonna just work on this one.
Yes. Good.
This indictment states that on or about April 20th, 2024.
Esta elección es esta elección
April 20th, 2024.
2020
In Jefferson County, Texas.
en Jefferson County, en el condado de Jefferson.
You operated a motor vehicle
Que tú manejaste un vehículo
in a public place
en público, en un lugar público,
while you were intoxicated.
mientras estabas intoxicado.
That is a crime.
Eso es un crimen.
Paragraph 2 of the indictment further states
Párrafo 2 del indexio.
that you have 2 prior convictions relating to driving while intoxicated.
Que tú tienes 2 anteriormente convicciones manejando intoxicado.
Namely, On May 9th, 2013,
En mayo
9th, 2013,
2013,
in County Court at Law Number 2 of Orange County, Texas,
en el condado de Orange.
you were convicted. See, Orange County, Texas,
En Orange County, en el condado de Orange.
you were convicted of operating a motor vehicle while intoxicated.
De que tú estabas manejando intoxicadamente un carro.
Do you understand?
¿Entiendes?
Is that true?
¿Es cierto?
Are you
Yes.
pleading true voluntarily and because it is true?
Está diciendo que estás diciendo que sí es voluntariamente, que las decisiones que sí es cierto. Yes.
And raise your right hand now. Do you solemnly swear or affirm you will make,
Dices la promesa y estás prometiendo.
you will answer truthfully all the questions the court and the attorneys may ask you
Que vas a responder las preguntas de verdad que
And-
el corte y el abogado te responden.
and all statements you make during this hearing will be the truth.
Y que cualquier cosa que lo que tú estés diciendo sea verdad.
So help you God.
Yes. Adiós.
So once again, you can lower your, on May 9th, 2013, in Orange County, Texas, were you convicted of operating a motor vehicle while intoxicated?
De nuevo, que si en mayo 9 del 2013, en el condado de Orange, le dieron una convicción por manejar intoxicadamente.
Sí.
After that,
Luego,
on October 19th, 2023,
en octubre 19 del 2023,
in Jefferson County, Court at Law Number 2,
en la Corte 2,
were you convicted of operating a motor vehicle while intoxicated?
de nuevo,
Is that true or not?
es verdad o no.
Are you pleading true to these prior convictions voluntarily and because they are true?
¿Estás diciendo que todo esto es verdad voluntariamente? Yes.
And so how do you plead in this indictment? In paragraph 1, are you guilty of operating a motor vehicle while intoxicated on April 20th, 2024 in Jefferson County?
¿Cómo tú estás diciendo que plegaria? Está diciendo que sí. ¿Cómo lo está diciendo la plegaria que en abril? What's it
On or about April 20th, 2024 in Jefferson County.
En el condado de Jefferson, en abril 20 del 2024, del 2024, que sí te está manejando intoxicadamente. ¿Cierto? ¿Eres culpable? Yes.
And on paragraph 2 of the indictment, are these prior convictions of DWIs true and correct?
En el párrafo 2, que es los antiguos, si son verdad. Yes.
Do you understand you are facing a third-degree felony?
En tienes una felonía de tercer grado. Yes.
Which means if convicted, you face no less than 2, nor more than 10 years confinement in prison.
Si te si eres culpable, te van a dar de 2 años de cárcel. Si ellos te encuentran convicción, si eres culpable.
And
¿Entiendes?
a fine and a,
¿Entiendes?
Sí, sí.
Yes.
yes, and a fine up to $10,000 can also be assessed.
Y también te pueden dar un cálculo de $10,000. Hasta $10,000. ¿Entiendes? Yes. No, no,
An agreement has been reached between your lawyer and the district attorney.
Ellos han acordado que hay un acuerdo de
You will-
tu abogado y el distrito, el abogado del distrito,
You will be pleading guilty,
que va a ser si es culpable,
found guilty of this third-degree felony,
esta felonía de tercer grado,
sentenced to 10 years in prison.
y dice que te van a dar 10 años en prisión.
But
Pero
that prison sentence will be suspended and you will be placed on probation for 10 years.
Este de los 10 años de prisión va a ser suspendido y te van a dar 10 años en probación.
You will also be fined $1,000
Y te van a dar, vas a tener que pagar $10,000, solo $1,000.
and you must serve 10 days in the county jail as a condition of probation.
Y también tienes que ir a estar 10 días nada más en la prisión del condado para probación.
Is that your understanding of the plan?
¿Entiendes?
Sí.
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Si él decide, si él aprueba esta aprobación, entonces tú no puedes decir o cambiar o ¿entiendes? Sí, tiene que ser, sí. Yes.
I show you what's marked as States Exhibit 1 here. Did you sign that document?
¿Tú firmaste ese documento?
Did you understand it?
¿Entiendes este? Sí, lo que te van.
Is everything true and correct there?
¿Es todo verdad lo que está ahí y correcto? Yes.
See? Yes?
Yes.
Okay. States Exhibit 1 is tendered into evidence.
No objection.
Without objection, admitted. This states that you are mentally competent to enter your guilty plea.
Está bien mentalmente que tú puedes decidir que está
You understand what you're charged with.
y lo que está bien los cargos.
You are guilty of this crime.
Y si estás,
De acuerdo.
si estás, si te encontraron que estás
This third-degree felony of
grado,
operating a motor vehicle
manejando intoxicado,
in a public place
para público,
while intoxicated.
y estás intoxicado.
You are giving up your rights to a jury trial,
Está ordenando tus
and
derechos.
you are totally satisfied with the representation provided by your lawyer.
Satisfecho con el representante de tu abogado.
All of this is true, so help you God.
Y eso es que Dios dio. Eso es todo cierto.
States Exhibit 1 tendered into evidence.
No objection.
Without objection, it is admitted. I'm going to follow this agreement.
Va a seguir ese.
Anything further?
Perdón.
So, Your Honor, we have agreement subject to your approval that safety is a condition of probation. And he's ready to do that.
I don't see it in.
There's an amendment, I think.
There it is. Additional terms. What was his blood alcohol level?
168, I think.
Oh, one of the terms of probation
Entonces, término de la aprobación
will be that you must you will be placed in custody
que te van a
and
vas a estar en-
you will be ordered to attend and successfully complete a program
y vas a tener, te van a ordenar de completar un programa
called the Substance Abuse Felony
abuso
Facility.
felonía.
which will help you
que te va a ayudar
with your problem
con tu problema.
so that you don't commit further offenses. How long is that program?
It's, so it depends. In the facility, it's about 6 to 8 months. And then he's gonna be taken into a halfway house, so about a year.
So he must have had what happens here is what we do when we deal with defendants who have a long-term alcohol or substance abuse drug problem. He must have that.
Right.
And we're going to help him beat that problem.
Para que ya no tengas ese problema.
So you're going to be in a hospital-like facility for several months.
Vas a estar como una hospitalización como hospital va a ser,
To assist you
para que te ayuden
from your addiction to alcohol.
por tu adicción al alcohol.
Do you understand?
¿Entiendes?
Sí.
Yeah.
All right, I will find that the defendant, if nothing further, the defendant has pleaded guilty to paragraphs 1 and 2.
Encuentra que tú has decidido que
Which
estás mal. Y
constitutes
el párrafo 2
which constitutes the third-degree felony
se trata de la tercer grado de felonía,
of operating a motor vehicle
de manejar un carro
in a public place while intoxicated.
en un lugar público intoxicadamente.
Because he has 2 or more prior convictions of DWIs, this is a felony.
Como ya tiene 2 o más, y esto es una felonía.
He has pleaded guilty voluntarily, knowingly, intelligently,
Tú has dicho que tú eres culpable voluntariamente.
and I find the evidence supports
Y él encuentra la
finding
evidencia
the defendant guilty beyond a reasonable doubt.
que tú sí eres culpable.
I am following this agreement.
Y él va a seguir ese acuerdo que está
And
llegando.
You, Mr. Salgado,
Que tú, abogado,
are hereby found guilty of this third-degree felony.
están encontrando culpable de esta tercer grado felonía
You were sentenced to 10 years in prison.
y te estás sentenciado a 10 años de prisión.
That will be suspended and you were placed on probation for 10 years.
Lo van a suspender y te van a dar 10 años de probación.
You must pay a fine of
Y
$1,000.
tienes que pagar $1,000.
Other terms and conditions of probation will be reviewed with you
Otros términos de la aprobación
by the probation officer.
por tu aprobación. Ella va a hacer lo oficial.
One of the conditions of probation, it will be, you will immediately be taken into custody
Una de las condiciones de la aprobación es que te van a llevar inmediatamente en
and
custodia.
you will be placed into a substance abuse felony punishment facility. Substance abuse felony punishment facility.
Alcohólicos Anónimos, de facilitar.
To help you with your problem, but do your part.
Tienes que hacer tu parte.
Commit to being successful.
Te he cometido en que seas que hagas las cosas bien.
You must complete a Texas DWI repeat offender program
Tienes que completar un de intoxicado, manejando intoxicado, un programa.
and you have to have an auto ignition interlock system.
Si tú tienes un carro, tienes que poner es un auto para comenzar tu carro.
In any vehicle you operate.
En cualquier carro que tú manejas.
Do you understand? That's important.
Es una maquinita que tienes.
See. Make sure you follow all these terms of probation.
Tienes que seguir
If you fail,
los términos de la aprobación. Pues si tú no lo sigues, si tú no lo sigues,
your probation could be revoked
lo suspenden tu aprobación.
and you could be sentenced to up to 10 years in prison.
Y te pueden sentenciar hasta 10 años de prisión.
Be successful.
Hazle cosas bien, ¿ok?
See the probation office. Good luck.
Aprobación, thank you.
Hasta luego.
Hasta luego.
Here, is that? Thank you. You know, when I'm speaking during translations, I almost shout, you know, like, it's just a natural, it's like. You're treating them like they're hard of hearing, it's not translated.
Judge, back to jump Anita Brown, she did show up, she's sitting in the jury box now.
Well, she is in custody. Where are you? You were late, you, or an order for your arrest. You're gonna interrupt me?
Oh, sorry.
I don't care what you were. You weren't in court when you were supposed to be, ma'am. And when that happens, it's untimely and a warrant has been issued for your arrest and you would be arrested. But we're gonna take care of all of that. Come on out. You got the file? Okay. It works like a train. I've got a jury sitting out there that was supposed to be, we're supposed to start a trial at 9:30. And I don't like it. I don't like us to be late on anything. And this is important. You're looking at up to 10 years in prison. I'm speaking. You're looking at up to 10 years in prison. If it were me, I'd have been here at dawn, but that's just me. This is important. We're gonna treat it important, whether you do or not. You're charged with this 3rd-degree felony of theft, which carries with it up to 10 years in prison. What are we doing today?
Judge, this is a all situation, if she's making payments, actually, she was upstairs, I think, making a payment today. And it's gonna eventually be dismissed by the state on payment in full.
What are we doing today?
I think reset 60 days.
I'm gonna reset it 40 days, 4 weeks to see where we are. Okay, get a reset. Get a reset. Don, what else do you have? Don, is that it for you? I've got Victor Green. We doing it? This is. Where's Langston? And I've got Alan Richardson and Paul Smith. Who's your attorney? John?
That's gonna be.
Where'd he go?
I don't know where John went.
We gotta get going. I got a jury out there waiting. He was
John.
Okay, I need him to get rid of these dispositions here. Looks like I've got Mr. Green, Alan Richardson, and Paul Smith.
They all need to enter the other page. I didn't know what it is.
Come on out. Let's go. We're ready. Who are you?
So.
Good to be. Your name? Paul Smith. Come on up, Paul. Wait, who's your client? You got that man? Come on up. Stand by.
Reset, Judge. That's all scarier.
I had to take a drug test.
Yeah, that's the drug test.
Great.
That's
Okay. Get a resetting.
He's been reset.
You don't have any dispositions. All of these are John's.
No, it's mine. I got.
Disposition.
Who is it?
It's Victor Green.
That's your final answer?
Judges number 2 on your new and improved trial docket.
Victor Green.
Doing the done.
Where is Victor?
He's in the back.
You're going, you getting? What's he doing in the back? Is he testing? Victor Green.
Judge, if you will be patient with us, I believe we got dispositions on all the matters on the trial docket.
He's taking it.
Please.
Good morning.
Good morning.
Good morning.
Good morning. How are you, sir?
Good.
Mr. Mr. Williams.
Yeah, I'll get them.
Yeah, Larry.
Good morning, you're Miss Larry Fitzgerald Williams.
Yeah.
And this is cause number 25 DCCR 0985 and 24 DCCR 1790. And where are we on this? What is the announcement?
Well, Your Honor, we would like to, with some pre-trial publicity that this case had last week, along with some pre-trial publicity early on in the case, we're gonna be putting together a motion to change the venue. And I need about we want to have a hearing, and I'll just discuss this with the ADA about having a hearing in about 3 or 4 weeks on the motion to change the venue.
Okay,
Because they had a thing with Abbott last week that I think negatively impacted Mr. Williams in his space. And that we need to put together this motion to change venue because of the severity of this charge.
so I will I'll just do a normal reset, which
Yes.
is about 30 days.
Yes, ma'am.
If you'll get that filed, once that's filed, I would anticipate how long for that hearing to take place? How many, you would have a couple of witnesses, I would
Yes,
assume?
ma'am. Yes, ma'am.
Mr. Smith
I think it could be done in a morning too.
in an hour or so in the morning.
Yes, ma'am.
So what we'll do is set it, well, it's gonna be set at normal time until we get that motion.
Yes, ma'am.
Once the motion, we'll keep it on that day and let's just
Okay.
make it at 11 o'clock on that day. But, and that way I need to make sure, or I need you to make sure and get that motion
It'll be.
filed, and that way we'll
Yeah.
do it at 11 o'clock on
Yes,
the
ma'am.
next court date.
Yes, ma'am.
Okay?
Yes.
Yes.
In reference to my case, I filed a motion for discovery. It's been partially satisfied, but the medical records, if you go on the discovery page, have not been scanned. And what I want to do is file a motion specifically for the medical records to be given to me as a PDF file, not a TIF file. Sometimes they do.
Can you, why don't you get with Mr. Smith? If Mr. Smith refuses to do that, then let me know and I'll get involved. But if y'all talk, I'm sure if you also could probably get a thumb drive and they can download it that way. I'm sure they'll accommodate whatever you need. But get with Mr. Smith if for some reason there's some things that you think you're not getting that you've talked to him about, let me know and we'll take care of that.
And so I'll be required in 30 days reset for him. I'll make that the same appearance.
I mean, if you're going to join in that motion, I mean, we're not,
But I'm
I
not,
would,
that's a separate case, so I'm not. gonna do
Yeah.
that motion.
I think it would primarily be with regard to the capital murder case and
Sure.
not yours. So I would think, let's see, we'll go forward. I would assume Mr. Smith is going to want to go forward with the capital murder first.
Absolutely.
Okay.
So
Well, I'd rather, if we need them both here, I don't want them to have to transport defendant twice.
Right.
But for the next hearing, if that motion's filed, the primary purpose of that motion will be for the change of
Yes.
venue, and you won't be it won't be necessary for you to be here.
and so
We'll give you notice of it. But if you just want to call and talk to Ms. Holmes and make sure what it's set for,
and they'll email me a new setting for him in reference to the 24 case.
I'm going to keep the cases together.
Yes,
Just because that's easier
okay,
I'm not gonna have Mr. Williams coming one day on transport
Right.
for Mr. Cash and one day for you. I'm gonna keep the cases together. For the next hearing, I'm telling you, you're gonna get a notice of it,
Right.
but you don't have to be here.
and then
We'll take care of Mr. Cash's motion, then we'll see where we get after that.
Okay.
Yeah.
Okay?
I'll send him a thumb drive.
Yeah, this is the first I've heard of an issue with.
Well,
Okay.
I
Just, yeah, give them a call. Just, y'all work that out the best you can, outside of court. And if there's any issues, then let me know and we'll handle it here. Okay?
Thank you.
Thank you.
Thank you, Judge.
Yes, sir. See, is Mr. Leish here? Yes. Good morning. On Heriberto Chavez. Good morning.
Good morning.
We also have translator.
Okay, good morning, Ms. Burks. How are you? Good, how are you? Please raise your right hand. Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? Thank you, ma'am. Good morning. Are you Heriberto Chavez?
Yes, ma'am. Yes.
And this is 25 DCCR 0559. Mr. Chavez is charged with deadly conduct, discharging a firearm. And what is the announcement?
We are gonna ask for a reset, Judge. I'm kind of new to this case. He was at the Jefferson County Jail and then moved to LaSalle, and we didn't realize it, so there was, anyways, got to meet with him, but need to go through the media.
Sure.
And Ms. Delay just approached me about changing my offer. I told her I don't see myself doing that on this case. So we'll just need to make sure she has all the discovery she needs so she can go.
Okay. And so what I'll do, Mr. Chavez, is reset your case for about 30 days. And that'll give Ms. DeLage time to come visit with you over at LaSalle, go over all of the discovery that she's received, and we'll get a final decision on what do you want to do with your case at that next court date. Thank you. Thank you, Ms. DeLage. Thank you. Thank you, Ms. Burge.
Yes, ma'am. Yes. Thank you.
Ms. Burge, are you here on anything else?
Next door.
Okay.
Yes, ma'am.
Thank you. I was gonna try to get you out of here if you needed something.
Yes, Judge.
Mr. Eckhart, you've got Alvin Wade.
Judge, he needs to be fingerprinted.
Okay. Did you already ask for him to be fingerprinted? Okay. We get Alvin Wade, if we can get him to.
Okay.
Good morning.
Stack on.
Good morning. I think she's got another that she needs to want to.
That email about it, exhibit 10.
Thank you very much. Look at that.
Judge, after Mr. Eckhart pointed out certain impediments to our prosecution, I have decided to waive both of those enhancing paragraphs.
Okay. Thank you very much. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Eckhart, will your client waive the formal reading of the indictment?
We do, Judge.
Mr. Wade, in clause number 25, DCCR 1648, you, the state's elected to proceed on count one only. It alleges that you committed a third-degree felony offense of possession of a prohibited substance in a correctional facility, and that is from July 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Eckhart?
Yes, sir. Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask that to everyone. Are you a U.S. citizen?
Yeah.
Yeah, okay. State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Wade is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited substance in a correctional facility, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams. All right, good luck to you, sir. Stay with that, Mr. Rowe. Mr. Rojas, you have Taylon Douglas. Taylon Douglas. Morning.
Good morning.
Morning.
It's not that.
This is, yeah, this. Good morning. Are you Taylon Douglas?
Yes.
Give me just a second. Good morning. Good morning. All right, will your client waive the formal reading of the motion?
He will, Your
I
Honor.
didn't already have that, sorry. This is cause number 25, DCCR 0895. And Mr. Douglas, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony. And that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation in count 1 only, by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025, which was the same date of your last hearing. And so, is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes.
And because it's actually true?
Yes.
So you never even made it.
I know, that's just, and I guess once you did that, you decided, screw it, I'm gonna do whatever I want, because I already know I'm gonna get in trouble, because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
I don't know, problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them? Even though you know you're gonna get written up and go to prison for that? Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm gonna accept this agreement. I'll hang on to it for now and then think about it. Let's see, I'd like to see. Oh. I'm about to print this old PSI so I can take a look at it also. See, Mr. Rojas, you've got Sally Pope. Sally Pope. Let's see. Mr. Smith, this is yours as well.
You still in conflict?
Yeah. So we need to do the 1 year. Okay, are you Sally Pope? This is cause number 24 DCCR 21110. Ms. Pope is charged with assault on a public servant and was previously found not competent to stand trial. I'm going to take judicial notice of the court's file. Ms. Pope was sent to the John Dunn Behavioral Science Center for competency restoration. I've received the report from them dated February 4th of 2026. It looks like we've got the trial competency evaluation report, which was done by a Leah Emery, Dr. Leah Emery and Dr. Samantha Guzman. That's dated January 29th of 2026. And finding is that Ms. Pope is still not competent to stand trial and unlikely to be restored within the time frame of the 120 days that she had there at the John Dunn Behavioral Science Center, and that further inpatient treatment would be warranted. In addition, I have a forensic psychiatry report prepared again January 29th of 2026. This is from Dr. Selek, S-E-L-E-K, also with the finding that Ms. Pope is not competent to stand trial at the present time. Also, a physician's certificate of medical examination for mental illness prepared by Dr. Selek. And the finding in that is that okay, so his finding is that she is not competent to stand trial, that outpatient treatment would be warranted is what his position is, and that the patient's condition is expected to continue for more than 90 days. That Ms. Pope suffers from mental illness that is severe and persistent, that a result of that she needs treatment. And then I have a second physician certificate of medical examination for mental illness. This is from a Dr. Nubia Luberis. And the finding in this report is also that Ms. Pope is not competent to stand trial, that she is mentally ill. And this finding is also that she meets the criteria for outpatient treatment. And so is there anything else with regard to competency from the state?
Not from the state, Judge.
Mr. Rojas?
There you are.
So obviously, just for the record, everyone knows that we do not have an outpatient competency restoration program here in Jefferson County. And so I have no choice but to find that Ms. Pope is still not competent to stand trial. Find while the recommendation is outpatient treatment, because we do not have an outpatient treatment program for competency restoration, I'm going to order the 1 year civil commitment for Ms. Pope to the appropriate facility. Obviously, if competency restoration is attained before then, we'll get her back here. Otherwise, we'll await the report from whatever facility she goes to. All right, so we're gonna try to get you some more help so that we can go forward with your
I
case.
go to Slidell in Louisiana.
I'm not sure where those, it's not up to me where they send you, it's wherever the best place is, okay? Okay, you can go back with the bailiff. Then, Mr. Rojas, you've got Kaisha White. Well, no, because he's gonna need to, I don't think they can make all that. He's gonna be, so if he's if he's actually picking the text, he's like, so. Yeah, let's, just reset. It's just one, right? We're gonna reset, Brenda Sanchez for Mr. Kimler. He's in trial over in drug court. He will be here at 1, Mr. Nichols, for our hearing, but we're gonna reset his morning. And I think it's just Ms. Sanchez. Yes. Okay. All right, are you, Kaisha White? Yes. And this is 24 DCCR 2063. Ms. White is charged with assault on a peace officer. Mr. Rojas, what is the announcement?
Judge, we're actually here for a competency review, competency hearing this morning.
Oh, I'm sorry. Let me do
And
that.
then
Okay, let me take
also-
judicial notice. Let's do that, or go ahead.
She's also, she
We've
pled
already played this case.
January 7th of 25. She didn't show up for sentencing.
Okay,
And when she was brought into custody, she was sent for competency.
okay. So did I,
She's never been sentenced.
She's never been
Yes.
sentenced.
but did we get a PSI? or
We did, yeah,
anything?
we did. She just didn't show up for the punishment hearing.
What date is it?
January 7th was the plea. She was set for sentencing February 24th of 25.
Oh, why this would have been scanned in. It's okay. So let's do this. All right, so let me do this first and take judicial notice of the court's file. And Ms. White was previously found not competent to stand trial.
No.
No,
This is
she was, sorry,
Found competent.
got it. Okay. She was evaluated for competency to stand trial. I've received that report from Dr. Rapon dated January 24th of 2026. The finding in that report is that Ms. White is competent to stand trial. Is there any other evidence with regard to competency?
There you are. Not from the state.
Then at this time, based on that report, I will find that Ms. White is competent to stand trial. So have you spoken with Ms. White? Is it y'all's position to go forward with that?
I spoke with her about the PSI, about the previous plea, Your Honor, and she indicates to me this morning that she would like to go forward with probation. Is that right, Ms. White?
So when you were here last year, you entered a plea of guilty, and that was going to be with a deferred probation for 7 years was going to be the plea deal with a $500 fine and follow all of the rules and conditions of probation. So you've already done that plea. Do you want to go forward and get that probation today? Yes. Yes, the problem is it's been so long. I don't have those. How can we find the plea papers? So it'll be from last year though, from January 7th of 2025, right?
Yes.
But probation doesn't have. Somewhere there should be an old PSI that has
And that's
their
what I
judgments, their orders.
And that's what I just want to
I
go.
believe it's on that PSI I just gave you. Didn't it?
What the actual order says.
Oh,
Yeah, we get other,
Oh,
okay. But if I do it today and we don't have those orders, is that something you can get with? To go back and get them to recreate? because they've already been created. The date's obviously wrong, but they're somewhere. Somebody created them back then. Yeah. Yeah. The, on Mr. Smith's PSI, it just has that short, the supervision plan, not the orders. So when we're done, he can get you a copy of that also to see what they had done at least back then. It just doesn't have all of the orders that you guys attached.
Okay, send it to you.
Thank you. They're almost exactly a year from the sentencing date. Okay, so any reason then not to go forward with sentencing? We need any type of updated pre-sentence report, or you guys think we can get it done?
I think we can do it today, Judge.
No evidence that either of you know of any arrests since last year? Who was arrested at Midland? You were arrested in November before Christmas. You remember when you were? Yes. Do you remember when you were arrested? Yes.
Were you in jail for Christmas?
All right, so what I'm going to do, Ms. White, I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to again find, based on Dr. Crapon's report, that you're competent and understand the nature and the consequences of that previous plea. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 7 years. You are ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That will include being on a special mental health caseload so that you can get whatever help you need in order to understand what's going on and be successful with probation. Okay? Do you understand?
Could you elaborate, Your Honor?
Yeah, so tell me what you think and what you understand about the probation that you're going to get. Do you have a question about that specifically? So what's going to happen today is if I go forward and you get out of jail today, probation is going to give you some paperwork today. And you need to go straight to the probation office when you get out of jail. Do you understand that? Yes. Okay. When you get there, they're going to go over all of the rules and the conditions and everything that you need to do so that you don't end up back here in custody because you didn't follow a rule. Does that make sense? Because what happens is if you follow all of the rules that you're supposed to on probation, you go to whatever classes they tell you to go to, you get any counseling, treatment, whatever it is. If you do all of those things, then you will not have to go to prison. You'll be able to, this case will be over when the time frame is over and you won't have this conviction on your record. Do you understand that? Yes. If you don't follow all of the rules and you don't show up maybe for an appointment or you test positive for drugs or whatever the rule is, if you break the rule with probation, you can be brought back here in court. You could be found guilty of the offense And I could send you to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years in prison. Do you understand that?
I understand.
Okay. And so, I'm going to hand you the trial court certification that shows this was an agreement and I followed it, so you can't change your mind later and appeal. And again, so probation will talk to you before you leave today, but Ms. White, it's very important. Ms. White, it's very important that as soon as you're released from jail, you go to the probation department so that you can get started on probation, okay? So either today when you get out or first thing tomorrow morning, if you get out late, you have to go to the probation department. If you don't go, you're going to get arrested again and be back in court. Do you understand that? Okay. All right. Good luck. Thank you, Mr. Rojas. Thank you, Mr. Smith. And Mr. Smith, if you'll let probation look at that, please. Of the certification. Kaylin Douglas. Yeah. Kaylin Douglas. It should have been with oh, never mind. Did I print it? Nope, I haven't yet. I kept it. That's why. Okay. All right. So just for the record, and I've gone back to review the pre-sentence report just to remind myself of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, really, really wanted you to succeed. I really did. I wanted you to be able to go to ISF, but I can't not stick to my word. I told probation when you were here, I told you when you were here, no more incident reports before ISF or you're not even going to make it. And it has been 1, 2, 3, 4, 6, 7. What day were we here? Dozens, at least. The sentence date was supposed to be, oh, the sentence date was November 18th. So since November 18th. You've been caught with a, looks like kind of a makeshift tattoo needle. We've got 1, 2, 3. Four or 5 at least times when you have been exposing yourself while masturbating to the officers, spraying other inmates with disinfectant spray, horseplaying, smoking. I mean, it's just.
Judge, I certainly understand your thoughts about it not being enough time, especially with the incident reports you're having a problem with on all these people in the jail.
No, I think I'm going to go along with what you guys have agreed to. I just wanted some time to look at it. The I'm just reminding myself of all, I mean, the fact that you got this in the first place, because we went through, I have it all marked off on this PSI, your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow the simple rules. So, I am going to, let's see. So I have, documents here on this tablet that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I go along with this agreement, that you're waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Okay, something wrong. Find you guilty of obstruction or retaliation, a 3rd-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're going to make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're going to end up doing the whole 4 years. But you're eligible for parole in less than 2. In about a year and a half, you're eligible for parole. And that's going to be 100% up to you. And I can assure you, you're not going to get it if you keep acting like this. All right. You can go back with the bailiff.
Yeah.
Thank you.